25 storm.
Just as I bring the gavel down. Okay, good morning. This is the executive session of the Senate Judiciary Committee. And we will be going until noon, and then we will be switching hats and we'll start having some public hearings. So the first bill, I'm going to try to go in numerical order. The first bill that we have is House Bill 481. And Senator Khan has an amendment. So I would like Senator Khan to walk us through his amendment.
Anyone needs copies of them.
Pardon?
If anyone needs copies, I have them.
Okay, if anyone needs a copy.
So we're the committee of the mind to have an ought to pass motion. I would offer this amendment. This amendment is essentially changing the de novo review in the Superior Court should somebody first go through the ombudsman process. In my conversations with, and you saw Attorney Tom Mullen, who I think represented the position of the Municipal Association as well, indicate no problem with the ombudsman if it provides greater access for people, streamlined access for right to know requests. But in that event, whatever those proceedings yield would be prima facie review for the courts to determine if there were any omissions in that review and take the decision of the ombudsman into consideration. And so that's the in any Superior Court review. So that's essentially what this is doing.
Okay. I'm sorry, Senator.
I was going to say I would move ought to pass on the underlying motion.
Okay.
On the underlying bill, excuse me.
Okay, so.
I'll second that.
Okay, so we have a motion about to pass on House Bill 481, but not as amended.
I would offer amendment
And
1350.
Senator Khan offers amendment 1350S.
And I'll second that.
And he's off it.
Oh.
Unless you
Sorry.
are you making a motion about to pass on the amendment?
Yes, I am.
Okay, Senator Khan is making a motion about to pass on the amendment. Senator Whitley seconds. The whole purpose of having the ombudsman is because, of course, there are issues concerning municipalities and how they're responding to right-to-know requests, that a person, rather than making a complaint and having to go directly to Superior Court to get that complaint heard, is that it would go to an ombudsman. And I'm wondering if this is going to make it harder for someone to actually go and make the complaint. Because if you're talking about having them go back to Superior Court, I'm just not sure if that is going to make it easy. I'm not sure. Maybe I'm misreading it.
Yes, let me make more clear. I think the process as proposed would allow one to go to the ombudsman and then go to the Superior Court with a de novo review. So that essentially it's two bites at the apple.
Okay.
And what the amendment does is say, if you choose to go to the ombudsman first, that record will be considered by the court and reviewed for any, should one wish to then go to Superior Court. It's not a de novo review.
So what you're saying is you're starting, instead of starting over with a fresh case in front of Superior Court, they have to take into consideration that they did go through the ombudsman process, and that will be entered into evidence in a court. Okay.
One question.
Yes, Senator Whitley.
So, unless there's an error, correct? So it doesn't allow de novo unless there was an error identified.
Yes, and then the error is investigated and adjudicated.
Okay.
Okay, are there any questions? I would envision, because we did this with the housing board. Instead of having people to go right to Superior Court, which is expensive with, you've got attorney fees and you've got court fees. We set up this board for people to bring their complaints to. So to me, this looks very similar, that this is going to be maybe a short circuit. So you don't have to go to court unless you choose to. But if you do choose to go to court, that record of the hearings and evidence and everything else that was presented during the ombudsman process can be entered into that court
It
record
will
as
be
well.
considered by the Superior Court, yes.
Okay. Are there any comments about this at all? No? Okay. So we have a motion of ought to pass on House Bill 481 on the amendment. Is there any further discussion? Mr. Lehman, you're kind of shuffling papers around. Okay. Okay, so we have a motion about to pass. Is there any further discussion? Seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, is there a motion on the bill as amended?
So moved.
Moved by Senator Whitley,
Second.
seconded by Senator Khan. Is there any discussion on the bill as amended? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay.
Move consent.
Senator
Second.
French, oh, we're starting already. Senator French moves consent, seconded by Senator Whitley. Is there any further discussion on the consent calendar motion? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay. We're going to do what we've been doing. It worked out really well for Jenny. Not really, but she didn't have to go and chase people down. So anything that gets put on the consent calendar motion, I will take out and I will work with Jenny, so that way she's.
That would be my recommendation.
I'm so glad, Senator, that you agree with me.
Consensus already today.
Consensus. Okay, let me do this. Okay, next we have, if we're doing numerical, let's see, what we got next is I have House Bill 629, an act relative to the home cultivation of cannabis plants and possession of certain cannabis-infused products.
I move OTP.
Okay, Senator Whitley moves on to pass. Is there a second?
Second.
Seconded by Senator Khan. Is there any discussion? I think we all pretty well know where we are on this bill.
I think this is a great bill and I'll be supporting it.
Senator French, I knew that was exactly what you were going to say. Senator Whitley?
Yeah, just really briefly, I think, we have learned a lot from, the past 40 years and the so-called war on drugs. And I think the reality is that it's been shown that the war on marijuana in particular just doesn't keep us safe. It can often waste taxpayer dollars. And in many cases, it can really ruin people's lives. So that's why I'm supportive of it.
Okay. Senator Khan?
Yes, thank you, Madam Chair. What I recognize is that even with the therapeutic market that we've created, the expense that some people are experiencing is not quite getting them to the kind of therapy that they're seeking, and that even the dispensaries are supportive of this, I think, is indicative of therapeutic market and this market can coexist and provide mutual benefit. So I think it's an important step for us to take.
Okay. Is there any further comments? Senator Gannon?
I am fine with laws would pass with decriminalization, with therapeutic cannabis. I think it's a bridge too far if it's going to be in every house. So I did serve on every household can have plants is not a good optic for me with kids. We're in the middle of a drug crisis. We don't have enough beds. I just think it's a bad signal. But besides that, I served on the Marijuana Commission 3-4 years ago. In every single state, when we had the attorney generals come in, we had all the state leaders come in, they all admitted to one thing, that the juvenile drug use went up. And so if you look back at our report from 3 or 4 years ago, every state who we talked to, juvenile use goes up. The more you have, which makes sense. You have more product in the state, they see their parents smoking, not as big a thing. I think you're taking away, we talk a lot about education, where kids go. If you're trying to be an AP Calculus and all these hard things and being on sports and trying to get ahead in life, this is going to be a setback for you. It's not going to help you study. It's not a good thing, and it's not what I want my kids, and I really don't want this, the look for the kids of the state of New Hampshire. So, nope. Thank you.
Okay, Senator French.
Thank you, Madam Chair. So I don't believe legalizing of cannabis is going to have an effect on the amounts of people who will partake of it. Those who want to use it now, use it. Those who want to grow it, grow it. This just keeps those that are doing it in the dark shadows, so they aren't arrested, to have them come to light. And I see no problem whatsoever where this is already legalized in Maine, Vermont, Massachusetts, and the whole country of Canada. I don't see any problem with passing this legislation today.
Okay. Is there any further discussion? Senator Whitley?
Yeah, I would just say, I mean, Senator French just sort of mentioned the other areas. I think, certainly I'm a mom. I want to make sure my kiddo is focused on what he needs to be focused on as a child. But, the thing is, we all, every house, I'm sure, or many houses have alcohol in them, and we know how to keep our children safe. I think that's a parental, support issue. And it is the case that all the states around us, we live in New England, it's an incredibly small area of the world, and we just continue to be an island, which it doesn't make sense to me anymore. Thank you.
Okay. Senator Gannon?
Final thought. I don't care what Maine, Vermont, Mass do. In New Hampshire, we make men of granite. We're strong. We need backbone. My father told me, you want to be a lawyer, you want to go to the FBI, they're going to make you go on a lie detector test. This is not going to be a good path. So I sat on many basketball team. Everyone else is smoking. I walked home because I knew it wasn't going to be good for me. But if you had said, everyone does it, it's legal, it's in your house, I probably would have tried it. Would it have killed me? Probably not. But it is not going to help kids do well. I think they're going to be more kids enslaved to not doing quite as well and reaching their potential if they're smoking pot all the time. I think if their parents are doing it, they're more apt to try it and do it. I knew it was wrong, and I was someone, Senator French has said many times, he was tempted by things that were legal. I, on the other hand, went maybe a little more straight and narrow, maybe a little more boring. But no, I want my kids to know it's wrong, and I don't approve of it. Thank you.
I would just say, in addition to men in granite, we also make women in New Hampshire too, right?
Sure.
But not out of granite, I'm
I
sorry.
meant that as a
Men
gender.
out of granite?
I think this
Gender
conversation
inclusive.
has definitely gone sideways. Let's get focused back on this. We have a motion of ought to pass. Is there any further discussion?
No.
Okay, seeing none, all in favor say aye.
Aye.
No, I'm not saying aye. Any opposed? No.
No.
No. Okay, so it's 3-2. Which one of you would like to take this out?
I'm happy to take it out.
Okay, Senator Whitley's going to take it out.
I didn't mean
Okay.
to steal your thunder, Jay.
Yeah, I was lost in thinking about the next bill. The next bill we have is House Bill 1011, an act relative to the penalty for criminal mischief. We do have an amendment. It is amendment number 1539S. And Rick, would you like to discuss this?
Yes. Good. Just amendment.
I sent a memo around to all of you about this bill. When it came up last time, I looked at it and I thought that something looked kind of funny in it. And the memo traces the history of Section 6 of the criminal mischief bill. And basically, over 13 years, the criminal mischief bill migrated from a provision that provided restitution for anybody who defaces the old man in the mountain to a provision that creates a general penalty for any criminal mischief to public property. The problem with that was public property was already covered under Section 1 of the bill, and Section 6 has been a Class A misdemeanor. It's been reduced to a violation, but my read of it is that Section 6 is duplicative of Section 3 and is absolutely not necessary for any reason that I could see. So as it stands now, reckless criminal mischief of any property and purposeful criminal mischief of property with a value of less than $100 is a misdemeanor under paragraph 3. And it's also a violation under paragraph 6. And you probably shouldn't have the same act be covered by two different sections with two different penalties.
So this cleans it up.
Hopefully.
Okay. Okay. Is there a motion on Amendment 1539S?
Move on to pass.
Okay, Senator French moves on to pass. Is there a second?
Senator Whitman. No.
No,
Oh,
no.
second.
Okay, so Senator Gannon seconds. Is there any further discussion on the ought to pass motion?
Yeah, I would say we heard little to no opposition. I do appreciate hearing from the chiefs sort of more about how this really impacts the communities, and of course from our very own Terry Path. So I think this is something we can move forward on.
So we have a not to pass motion on Amendment 1539S. Is there any further discussion on the amendment? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay. Is there a motion for the bill as amended?
Move on to pass as amended.
Senator French moves on to pass as amended, seconded by Senator Gannon.
I'm catching up on the conversation, but this is accomplishing exactly what I think came out of the hearing. So I appreciate it, meaning that
It makes it clear.
everything is a misdemeanor and it leaves to the discretion of the court, the level of misdemeanor to be charged, so.
Discretion of the prosecutor that makes the charging decision.
Make the,
Thank you.
Right, which is important, I think. I mean, my concern initially was like, who are committing these crimes? Are they sort of young folks? But I think, that discretion is important.
right.
Yeah. Thanks.
Okay, so we have an ought to pass as amended motion. Is there any further discussion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay,
Move consent.
Senator French moves consent,
Second.
seconded by Senator Whitley. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay, okay, Jenny, we got number, I think this is the second one. Okay, next we have House Bill 1235, an act relative to compensation paid to a crime victim. All this bill does is it raises the maximum recovery from 40,000 to 50,000.
Yeah, the attorney, didn't we get positive
Yeah.
testimony on this?
Yep. I don't believe there was.
I move on to pass.
Second.
Okay, Senator Khan moves ought to pass, seconded by Senator Whitley. Is there any discussion on the ought to pass motion? Okay, seeing none, all in favor say aye.
Aye.
Aye, any opposed? Okay, is there,
Move consent.
Senator French
Second.
moves consent, seconded by Senator Whitley. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay, there we go.
Cruising.
Well, we're getting through. Okay, next we have
33.
House Bill 1296, an act relative to the forfeiture of items used in connection with a drug offense. Senator French has presented us with an amendment.
Yes, does everyone have that?
No.
It's Amendment 1415. I do.
You do? Sorry, it's right here.
14, I don't have a 14. Wait, 1296, no, I don't think I have that.
Senator French, you want to walk us through your amendment?
I will try.
Okay.
So, number one on page 2, lines 31 through 35.
Okay. So,
This talks about waivers. 31 through 35. Does not, this is,
are you sure? Do you have a
no,
different
I'm
one?
not sure.
Okay, because that doesn't deal with waivers.
No,
Are
I
you looking
know.
at 14, 15?
Looking at my notes here.
Okay. Well, Senator, why don't we do this? So the ones that, I mean, I think that, you know, people want to take a little bit of time. I think you
Yeah.
need to maybe take a little time to go through the amendment. And we can do it after.
Why don't we do that? Then I
Okay.
can line them
You're
up.
saying afternoon, right?
Yep, we'll
Oh,
do
that's
this one later on this afternoon.
No, wait, good,
That way everyone will have seen the amendment.
yep.
Okay. Next, we have House Bill 1333, an act relative to previous convictions for driving while intoxicated. We have an amendment that was given, request by the AG's office concerning the definition of way. And we have here amendment number 1530S. Everyone should have that. Okay.
That's it.
The other issue, I think with this bill, and I thought, you know, we can talk about it, is this one has a 20-year look back. I don't know how comfortable people are with a 20-year look back. I understand why you would want to do that, but I think we can hopefully say that a person at age 20 is very different from a person at age 40. And, you know, I just, to have that there, that they had maybe 1 or 2 offenses, I just don't know if 20 years is just too much. And so I just figured we could have a little discussion about whether or not you wanted to amend that to a different time frame, or keep the time frame the same, or,
Just so it's clear, this amendment is a replace all.
Yep.
So if you were going to go back and revisit the 20-year, you should make clear that
yeah.
you're
This
sticking to the
replaces
original.
everything. So what it would do is keep the amount of time that we have currently in statute, so it does away with the 20-year, and then just amends this with the definition of way.
So my problem was with it having a 20-year look back. That's a
Yeah.
long time.
Yeah.
10 years is plenty, and I'd like to keep it the same as it is now. So
Okay.
I would be in support of the amendment.
Okay, so are you making a motion about to pass?
I move on to pass on amendment, what's the number?
1530,
1530,
1530.
yeah. Is there a second?
second.
Second by Senator Khan. Okay, I see we're all kind of thinking the same thing.
Yep.
20 years was just way, way.
Too much, yeah.
Way too much. Okay, so we have Amendment 1530S. Is there any further discussion? We have a not to pass motion. Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, is there a motion on the bill as amended?
Move on to pass as amended.
Okay, Senator French moves ought to pass as amended. Is there a second?
Second.
Second by Senator Khan. Is there any further discussion on the bill as amended? Seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay.
I move consent.
Is looked.
Second.
Okay, move consent Keller, moved by Senator French, seconded by Senator.
Your
Whitley.
stare froze me in place.
So you did have kind of look like the deer in the
It did. It
headlights.
was like, what did I do? What did I do? What did I do?
Oh, no, no.
That's because women are made of granite.
Yeah.
There you go. Zing.
Turned me to stone.
I was giving his mom's, I was giving his mom. Yeah,
Exactly.
deadly. Okay, so we have a consent calendar motion. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay.
Senator
then
Carson, why don't you take that one
I'm
up?
gonna take this one out. Okay, next we have, House Bill 1335, an act relative to the parole board and the procedure for medical parole of prisoners. We have an amendment. The amendment is 1534S. We had a request to, you have it, Jenny?
Yeah, no, sorry. I just hated the whole script.
Just in reference, it changed the reference back to, prisoner.
Oh.
So that's all it does. I know, that was the request, so,
Not the Holiday Inn.
Well, I mean, may I?
yeah, no, please, go ahead.
So I think this is inconsistent with what the Department of Corrections has been asking us to
Right.
do. They have really, and I would defer to them because they are the ones that sort of tell us how important language is to safety. And so I would be really, and I don't think that consistency within statutes are important, but I think if the Department of Corrections is telling us to change our language, I think we need to change our language.
So I think what's in statute should be explicit and they can use whatever they want when referring to their guests or their overnight guests. But in the law, it should be what it is, prisoner.
Okay,
So is this removing any references to resident?
it takes out the word resident and substitute prisoner.
So I would say that, that was something suggested by the parole board, but
Right.
the individual who, there was a Dr. Enriquez, he was a member of the adult medical parole board, and he, thought it was consistent to stay with a resident.
Yeah. So this, again, this was a request from the parole board. Senator Gannon.
Words are important. I like prisoner and inmate. I think it's clear. And I don't think we have to fall to a political agenda and use the terms. I realize Senator Whitley appreciates the situation people are in, but I'm very happy with calling them prisoner inmate, and I'm happy with using the words, and I know they have meaning.
I just wouldn't say, I have to say, it's not a political agenda. This is what the Department of Corrections is asking us to do, and a member of the medical parole board. So it's not a political agenda, it's what they're asking.
I'm sorry for saying that.
Okay, thanks.
Okay. Okay, so is there a motion on the amendment? Did we get an motion? No, okay, is there a
Move on to
motion?
pass on amendment 1534S.
Okay, so Senator French moves on to pass. Is there a second?
Second.
Seconded by Senator Gannon. Okay. Are you ready to vote?
We are.
All right. All in favor say aye.
Aye.
Aye. Any opposed?
No,
No.
Okay, okay, so we have an ought to pass as amended motion. Is there any discussion on, oh, no, we don't. Is there a motion on ought to pass as amended?
I move ought to pass as amended.
Second.
Okay, and seconded by Senator Gannon. Moved by Senator French, second, okay. So is there any discussion on the ought to pass as amended? I think that other than that word change, I think we're pretty much in agreement.
Yep.
That this is a good thing to do.
Yeah.
So,
yep.
okay. So we have the ought to pass as amended motion. Is there any further discussion? Seeing none, all in favor say aye.
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 Any opposed?
Move consent.
I'm not going to second that one. I would
was gonna
request
say,
that.
I see a floor amendment. I'm gonna do this. I'm like Johnny Carson used to do in Karnak,
Yes.
put the thing in. I see a floor amendment coming forward. So, okay, so, Jenny, no, I'm doing the consent.
Yeah,
No, it's not on consent. Oh,
No,
that would be a good one for Gannon to
Okay, Bill, do you want to
Sure.
take this one?
Yeah.
Okay,
talk about residents and
okay.
Spas.
spas.
Okay. Next, we have House Bill 1360, an act relative to penalties for controlled drug violations.
Oh, I'm sorry, what number was that?
That is 1360. I
would like to make a motion on that one of interim study if I could.
Okay, and we have a motion of interim study. Is there a second?
Second.
Okay, seconded by Senator Gannon. I have, I'm not a big person that supports drug usage, but we're talking about fentanyl, we're talking about heroin, we're talking about opiates, all the other, the drugs that we have struggled with over the past, 6, 7 years, and helping people dealing with their addictions. I just don't, I don't even know why we would even consider doing this. That's my opinion, and I'm gonna be supporting the interim study on this. There has to be, I know the ACLU has said, stop saddling thousands of people with felony records each year for drug possession, but these drugs, we've all agreed, are against the law. And if you don't want to be saddled with a felony, don't do it. It's that simple. Why are we saying to people, okay, yeah, we passed the law, you shouldn't take these drugs, you shouldn't be in possession of these drugs, but if you are, we're not really going to do anything here. I just don't understand, and what kind of a message does that send? It's not clear. If it's bad, it's bad. And I'm sorry, I'm going on a little bit about this, but I really do think the law needs to be clear, because we pass laws, we create these penalties, and then this bill is in part looking to exempt people from those penalties. So why are we doing that?
It is for first offense. It is for simple possession first offense, but even with that, I know that the majority, if not all people, are not arrested the first time they do something.
Yeah.
So it's probably the 30th time they've been, that they get caught and arrested. So therefore, I really think it's better to study this a little further,
Yeah, it needs
straighten
work.
it out, change certain drugs that are on here, take them off, and some of these, make it a misdemeanor for some of the drugs that are on this.
Yeah,
So that's why I'm going with interim study.
yep,
May I?
yeah, no, please.
So, and I certainly am sensitive to, we don't want to be encouraging drug use. I get it. Again, I'm a mom. I only have an 8-year-old, but certainly it's something that I'm going to be watching for, of course. But I think in this case, we did have this bill last year and it was too big. And so this year we're very focused on this simple first possession. Mm-hmm. So I think this is a more refined bill than we saw last year. And I think, I certainly hear the concerns about fentanyl and those things, but I think that the bill continues to give discretion to the prosecutor about what they're going to charge, right? So if there's a certain, depending on what the drug's involved. So I think if it's the case that the amount of a certain drug doesn't look like possession, it looks like something else, then the prosecutor can do a different charge. I also look at it from the substance use disorder side. I think that, we do know, and again, we now have 40 years of evidence that shows us that incarceration and felony charges, they're not a deterrent for drug use. So I think if we are truly looking towards a deterrent effect, it's not through incarceration. I mean, that's just the reality, and that's what the data has showed us. And so I think this is a good way to shift our focus in a very small way. Because this is not a super ambitious bill. I think this is a small way to shift our focus towards what we know actually, deters drug use and also treats it, which is SUD treatment. So that's why I'm supportive of this bill.
Okay,
I'm going to support the interim study on this. There's just there are a lot of words in here that it is not just simply a possession under this paragraph. And the range of the drugs is, under each class, is such a wide range. So I think that the testimony that this is using an axe when a scalpel would do is to your point of interim study on this. That's why I concur.
Okay, is there any further discussion on House Bill 1360?
Again, I had problems distinguishing between a possessory amount and a distribution amount. We had those poor military families the West Point kids who got killed a few weeks ago. It only takes like a grain of sand worth of fentanyl, carfentanil. They had never done drugs from all I can tell. They did a little bit. They were out having their leave after 3 or 4 years in West Point, and this one little thing that someone put in front of them killed them. So I think the smallest amount of certain drugs are so dangerous that we have to not let them be out there at all, and they have to be penalized so people don't play with them and do those things. So I want a severe sentence for certain drugs.
Okay, so we have a motion of interim study on House Bill 1316. Is there any further discussion? Okay, seeing none, all in favor say aye.
Aye.
Aye, opposed?
No.
Okay, so it's a 4-1. Interim study. Senator, do you
Sure,
want to do
I'll
this?
take that out.
Okay.
Thank you.
Okay, next we have House Bill 1388, an act relative to the unsolicited disclosure of an intimate image. We have an amendment, and that amendment is Amendment 1532S. And Rick, do you want to walk us through that?
Sure. All the amendment does is change the words used to require consent. The bill as it was passed over by the House had a much longer and involved definition of what is consent. This amendment would just simply say it's a crime when the person does not consent to receipt of the image. We have a pretty good history of understanding what consent is as a standalone word. When you put it in a longer sentence the way it is in the bill that passed, I think it becomes a little ambiguous as to whether it means something other than the consent as it's used in the law generally.
Okay.
If we don't mind taking a beat on this, I just want to touch base with, I know there were a lot of folks who actually
Yep.
worked on this bill,
So
so
we can hold
Perfect.
on this
Thank you.
one off and we
Appreciate
can
it.
do that later.
appreciate it.
Later, like,
Tonight.
This afternoon,
Yeah.
or tonight.
Yeah.
This afternoon, how
Yeah,
cute.
Trying to be, I know.
Yes.
Okay. Next, we have House Bill 1518, an act relative to the requirements for appointed guardians. Is there a motion on this bill?
Interim study.
Okay, Senator Gannon moves interim study. Is there a second?
Second,
Seconded by Senator French. I don't think this bill is ready for to pass. I understand where the representative wanted to go with this, but we know that these visits are expensive. And if you want to take in a foster child, who's going to pay for that? Do you want the foster parents to pay for that, or is the state going to pay for that home study? I have private versus public. Is this? I just see it as putting something in front of a kid who is going into a foster home. And I know on the public side, we do a really good job of vetting these foster parents. But I just don't know what's going to happen on the private side. And the cost of the agency visit shall be paid for by the guardian. And there's a 90-day window that it has to be done. So does this mean that the child is going to be placed in the home for 90 days, waiting for everything to come back? Or does this mean the child's gonna be in the foster home? A different foster home and then get moved? I mean, we just didn't really get, I didn't get a really good, understanding, I guess, perhaps. I just think that this bill just is not ready. We need to make sure everything is really clear, so.
Yeah, and I would agree. I think, certainly we both care deeply about children's safety, but I think this is an important issue. I think it does need a little more work because because these are so expensive, we don't want to leave out, $1,000 is a lot of money for some people. And so we don't want to leave out people who would perhaps, step up to be guardians. So I think we just need to think about it a little bit more. So I would support the interim study.
Yeah, and it doesn't say anything here about kinship, which we know the courts really try hard to place kids with a grandparent or an aunt and uncle or a sibling. How is that going to be affected? Because it says every guardian appointed shall, within 60 days of the guardianship appointment, receive. If you have a family that's lost mom and dad, and you have an older brother or sister who's of legal age and willing to take to be the guardian for their brothers and sisters, the family could be struggling financially. And do we do this for families, or is it just for? That's why I just don't think this bill is ready. So I'm going to be quiet now. Okay. So we have a motion of interim study on House Bill 1518 for today's 14th. Is there any further discussion of the interim study motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay, and is there a motion for the consent calendar?
So moved.
So moved.
Moved by Senator Whitley, seconded by Senator Friend. She got it
Giving me the
first.
granite stare.
Yeah,
Yeah.
okay, so we have.
Can't let it go.
consent-
Oh, sorry.
Oh,
Granite
that's
gaze.
right, Granite Gate.
Granite gaze.
There you go. So we have a consent calendar motion. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay. All right, we've got probably, well, maybe we'll do a couple more and then that way we'll break. I want to make sure you get lunch because you're going to be running back and forth. And we got to get our stamina up for this afternoon as well. Next, we have House Bill 1540, an act relative to recording custodial interrogations. Is there a motion on House Bill 1540?
Move on to pass.
I'll second.
Okay, Senator French moves ought to pass, seconds by Senator Whitley. Okay. We did get a lot of testimony.
Very good.
We were concerned about people who were very concerned about this bill. I can't support this bill, so this comes at a huge cost to the police department, especially the small departments. We've had unnecessarily poorly worded bill. Wording is problematic. Law enforcement too broadly defined. It's the Assistant Attorney General came in, they're opposed, turns the statute on its head. The penalty is too much. No allowance for asking for consent prior to custodial interrogations, violating existing RSA. Really asks, what are we doing here? So I think I would have preferred an interim study motion because I think there are a lot of questions on things, but we do have a standing ought to pass.
Unless
So,
someone
Do
wants
you
to
really
comment.
think
Yes.
there's that many problems with this, Madam Chair?
yeah, I think so.
I listened to it and I'm looking at this as a tape recorder and a digital camera, which are all cheap. But if you really think there are major problems, I could probably withdraw my
Senator, you vote the way you want to vote. I don't tell anybody how to
Yeah,
vote. You
Maybe
know
we
that.
could, maybe
we
we could
just hold
hold
this?
on. That's exactly what I was
Okay,
gonna
all
say.
right, we can hold that.
Because I do want to go over my notes. I have it
Okay.
down as ought to pass, so.
Okay, that's fine.
If you're going to pass it, there are a couple changes to make.
Yeah,
Yeah.
so we have House
Say wait.
Bill 1597, an act permitting arraignments for felonies and preliminary examinations to be heard in circuit court. This is the repeal of felony first.
I would move ought to pass.
Okay, we do, the committee was presented with an amendment from Representative Gordon.
Correct.
Has everyone looked at this? Yes.
It's 1235H, right?
Yes, 1235H.
Yes.
Oh, okay, got it. And that was requested, it looks, I have it in my notes that this amendment was requested by the judicial branch.
Yep.
See here.
Yeah,
Do you have that?
1235.
Yep.
So I ought to pass on amendment 1235.
1235H.
Second.
Senator Khan, do you have that
I
amendment?
do,
Okay,
I do.
okay. Yes, so we have an ought to pass on amendment 1235H. Okay. Moved by Senator French, seconded by Senator Gannon.
And I thought Chairman Gordon spent a lot of time
He
on
did.
this. And from a very, very informed perspective,
Mhm.
and where there was disagreement, it was actually mixed, right?
Well, it was mixed mostly with the county attorney.
Yeah, the county attorneys were not, they want to keep it.
Except for Merrimack County Attorney.
Well, there were three that, yeah, Merrimack definitely gave us testimony.
In support of the repeal.
And Hillsborough also supported it.
Yeah. So, okay, we have, are you okay, Senator Khan, to
I
vote
am.
on this?
I'm ready.
Okay, so we have an ought to pass on motion on amendment 1235H. Is there any further discussion on the proposed amendment? Okay, all in favor say aye.
Aye.
Any opposed? Okay, is there,
Move
a
ought to pass this amendment.
okay, Senator
French.
French, I know I'll get it right. Move ought to
6
pass
years,
as
he doesn't
amended.
remember my name.
So I gotta run one more time.
Yep, there you go.
Should remember.
So we, is there a motion of,
Second.
okay, Senator French moves ought to pass as amended, seconded by Senator Gannon. Is there any further discussion on the ought to pass as amended motion? Okay, Steve?
This is aimed at improving how our courts handle
Right, this
minor
program,
crimes.
because I was a member of Judiciary when this passed, was presented as, we want to try to see how this is going to work, and there are issues. And it's been probably a good 5 to 6 years since we enacted this. So there are a lot of issues with it, and whenever there's a big problem, it's maybe time to go back to the way we were doing it before. So we have an ought to pass as amended motion. Is there any further discussion? Okay, seeing none, all in favor say aye.
I
Any opposed? Okay.
move consent.
Okay, Senator French moves consent. Is there a second?
Second.
Seconded by Senator
Now I'm
Khan.
sleeping on the job.
Ah. You gotta be
He needs to
careful.
eat.
He was giving me his granite stare.
Ah,
Granite gaze.
and so we have a consent calendar motion. Is there any further discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay, Jen, this one's mine. Let's see what the next one is. Oh, geez, this one is the fetal life. Why don't we,
Let's do
is
it.
that one we're gonna do later on this afternoon?
Sure.
Yeah, I'm sure,
Okay.
because I'm sure people are gonna wanna talk about this. So, the committee is going into recess and will resume our meeting at 1 o'clock. Turn off.
Yes, you can. You can come around.
No, I don't. It's not like it's. I think it's just that drivers going up, okay.
Let's see where it's going to this.
Pardon?
I'll let's see where it's going to this.
Hey, I said.
I was here. When did I get here? For us. I didn't say treat me like an illegal and you did it yourself.
Oh, yeah, I think you're wow, I think we're about to start a hearing.
But now you don't even treat me.
Oh. I think we're ready, Senator, whenever you are.
Wait, one of my peeps.
I did.
Microphones are on. Okay. Committee will come out of recess and we're going to open our afternoon session of the Senate Judiciary Committee. We're going to start the public hearings and we're going to start with House Bill 1036 and call the prime sponsor, Representative Wolpert. Good afternoon, Representative.
Good afternoon. Good to be back with you. So for the record, my name is Representative Kurt Welper, and I represent Stratford District 3, the towns of Stratford and New Durham. And House Bill 1036 deals with a change to the attorney-client privilege exemption enacted last year. And it just adds a phrase at the end of the existing privilege that says there should be a balance, balancing against, the exemption is there and should be there, but it should be balanced against the public's right to know. Now, you might think that's redundant since it's in the Right to Know Act. But since this exact exemption was, which didn't exist at the time, but was understood by everyone to be part of their normal procedure, was the cause of the Supreme Court case that caused this exemption to be written into the law. I felt it was important for the law to recognize that this is a significant right to know issue, and there has to be a balance. The documents, any document that is attorney work product or attorney, work product, cannot be exempt from the right to know it. Much of the work that attorneys do is should be just plain public information. But if an attorney is hired to do it, it becomes attorney work product, and then it would be exempt from the Right to Know Act. And it shouldn't really be. So, and a great example was the case of the Hempstead SAU in the Supreme Court case that they had. The SAU asked for an investigation of itself, and they got that. Well, the results of that investigation should be public. That was the whole point of it. But because it was attorney work product, they said no. According to attorney work product privilege, which is the same attorney-client privilege, which wasn't even in the law explicitly, we're not going to give it to you. And so the people that wanted to know the results of that investigation had to go to the Supreme Court to get the Supreme Court to say, yeah, that should have been public. And then we write into the law attorney-client privilege. And it's not qualified. And because it isn't qualified, it's my concern that the court will read that as a blanket exemption for anything that is attorney-client related. That would be very bad.
Oh, Representative, I'm listening and I'm a little confused because we're talking about House Bill 1036 concerning access to government records and meetings. I think you might be speaking to the next bill, which is 1073,
I'm sorry.
which you also sponsored, dealing with modifying attorney exemptions under
Yeah, that's what I
RSA.
was talking to
Okay.
1073.
Okay, because I'm looking here at the language and I'm like, I don't see anything about attorney work product or anything. So this is, I just want to make it clear.
I apologize,
for
Madam
folks
Chair.
listening and for folks here.
If they're
that
always,
This bill is about meetings and notification for employees. So can you talk a little bit about that, please?
oh my goodness, I haven't looked at it. I have to look at the bill section. Oh, this one's even easier.
Okay, well, that's good to know.
Okay, so this has to do with disciplinary meetings for public employees.
Okay,
There's nothing in this bill which is not already in the law. It simply restates the existing law in somewhat stronger language. That's all it does. So right now it says, request the meeting, that what's struck out of there, request the meeting be open, in which case the request shall be granted. And the intent of that is that if you're going to have this kind of meeting, that the affected employee has the right to have a meeting and request that it be open. And all I did was say, instead of using language that's there, is to say, in which case the meeting shall only proceed after notifying the affected employee and determining if the employee requests to appear at the meeting or wishes to have an open meeting. In other words, you can't have the meeting unless you've met the requirements that's already there. Right? And this came to me from a gentleman who was wronged under this provision. He was denied his rights, and he approved this language. It's not like there's a just stronger to do the same thing.
so Representative, so basically what you're saying is anytime an employee, a public employee, and they're talking about dismissal, promotion, or compensation, that they have to notify that employee that they are going to be discussing that employee at their next meeting or at a particular meeting. And the second part is determining if the employee requests to appear at the meeting or wishes to have an open meeting. It's my understanding that anytime a body, an elected body, is discussing either the employment, anything to do with an employment, disciplining, dismissal, promotion, anything concerning a public employee, that is when you go into non-public. So are you saying that if the employee wishes to not go into non-public and they want to have these things discussed in an open meeting, the employee can make a request to the board that they want to have it be an open meeting? Or are you saying that if the employee makes the request, it must be an open meeting?
I'm saying, yes, I am saying if the employee makes the request, it must be an open meeting, and the existing law says, and requests the meeting be open, in which case the request shall be granted.
Okay,
So either way, it's going to be an open meeting if the employee wants it. That's why I said I didn't add anything to this.
okay. Hey, Senator Gannon,
Quick
and Senator
question for me,
French.
really easy question for you. So if I'm a select board and we'll say Sandown, Danville, wherever, and we have someone commit some heinous egregious offense, we can't just go into non-public and fire him. He has a right to be there?
That's correct. And that's the existing law.
Okay, thank you.
Senator French?
Thank you. Thank you. So I too am confused about this language. So, in which case the meeting shall only proceed after notifying the affected employee and determining if the employee requests to appear at the meeting or wishes to have an open meeting. So I don't understand that, what you're getting at. So you ask the employee if he wants to appear at an open meeting or a closed meeting or,
No.
okay,
So first of all, forget the amendment.
okay,
Just read the crossed out language. Right?
yeah,
So it says, has a right to a meeting. Okay, so we're that far. Has
Yeah.
a right to a meeting and requests that the meeting be open, in which case the request shall be granted. So right now, the law says you have the right to a meeting,
okay,
you have the right to request to be at that meeting,
okay.
and you have the right to ask for an open meeting, in which case it will be open. That's the law right now.
Okay, so let me stop right there. So if the employee does not want it open, it will be closed, you're saying?
Yeah, we normally, just like the
Okay.
chairman mentioned, you would normally go into closed session to do this,
Yeah,
right? But if the employee wants it to be open, then the law already says the meeting will be open.
okay. So,
Follow up?
follow up. Um, and if he wants it to be closed,
He doesn't have to do anything because you're going to do it in closed session anyway. This is why you can go into non-public.
and then the public cannot get records of that.
Well, so the records of non-public sessions are up to the board, what they do with those records. They may or may not be made public at any future time.
Okay. Thanks.
Are there any further questions? Senator Khan?
Sure. So what it seems like here is that the piece that's being added, the added language, because they already have the right to request an open meeting. It's that that the meeting shall only proceed after notifying the affected employees. So that's the piece that's being added. Those are the words being added.
Yes.
So there's a formal notification to the employee.
Well, that's true. There's no formal notification in the existing law.
Right. Which you would think
But
is a natural,
the law itself says that you can go into non-public, go up to line 4, and the last 3 words on line 4 are unless the employee affected has a right to a meeting and requests a meeting be open. And all I'm saying is, unless the employee affected has a right to a meeting, in which case the meeting, blah, blah, blah. So you have to make the determination of whether or not the employee has a right to a meeting in the first place. That's in the law now, then it's in the law now. And if the employee has a right to a meeting, then the rest of this comes into play. Now, it's conceivable that the employee would not have a right to a meeting, but that would be a relatively unusual case in my view. So if there is no right to a meeting, then there is no right to a meeting. But if there is a right to a meeting, and again, the whole point of this is not to add anything to the law. It's just to put the language in such a way that it's clearer that these things have to happen.
thank you.
Are there any further questions for the representative? Okay, seeing none, thank you, Representative. The chair will call Nate Gray.
Thank you, Madam Chair. Nate Grace for the New Hampshire Municipal Association. We do not have a position on this bill. As Representative Wolper stated, the way we interpret the language is that it simply rewrites the existing law. So just to provide an example to the committee as to how this currently works, you might have an employee such as a town administrator. They're accused of something. The select board does an investigation. Based on that investigation, they decide that they're going to proceed with some sort of termination potentially. As part of the contract the town administrator has, they have a right to a meeting. Typically, those meetings would be held in non-public session under the exemption that allows for employee discipline under this exemption. And then
as the law currently stands, if that employee for some reason decides they want that meeting to be open to the public, so not in a non-public session, they have that option. And the way we read this bill is simply that the representative who submitted it would simply be rewriting that to write it differently, since it does cause some confusion as currently written. I'm happy to answer questions.
Okay. Thank you very much, Mr. Grace. Are there any questions from the committee?
Thank you.
Okay, seeing none, thank you. Are there any other members of the public who would like to speak to House Bill 1036? Okay, seeing none, we'll close the public hearing. What I do with it? Oh, I think I put it in there. Sorry, Jen.
It's okay.
Yep, I did. Yep, you. Oh, let's see if I get this. Wait a couple minutes. Are you all set, Senator? Okay, good. Okay. Going to go ahead and open the public hearing on House Bill 1073 and recognize the prime sponsor, Representative Wolper.
Thank you, Madam Chair. Again, for the record, my name is Representative Kurt Welper. I represent Stratford District 3, the towns of Stratford and New Durham, and I'll repeat what I said before. So 1073 adds the words subject, not contravening the right to know law to the attorney-client exemption was enacted last year as a part of House Bill 108. And the point of this for me is that it be clear in the law that the exemption that we wrote in is not a pro se exemption, but subject, because, as it would be, you would expect in the right to know law, to be balanced against the public's right to know. And the best example of that I can give is the case that led to the exemption being written into the law last spring, where an SAU asked for an investigation of itself. Then an attorney do it, they got the results, and then they said this is not subject to the right to know because it's attorney-client work product. Well, the whole point of that was to find out what was going wrong in the SAU, and the public certainly had the right to know. So they went to eventually to the New Hampshire Supreme Court, who issued a ruling saying that there had to be a balance against the public's right to know. Now, at that time, the attorney-client exemption was not even in the law. It just was common law. Everybody understood it and had been used, and some would say abused, for a long time, forever. But now we wrote in this exemption, and especially considering the circumstances in which we did it, if I was sitting on the court, I would say, well, so we had this situation and it came up and it got settled, so we withdrew the decision, but the legislature has clearly spoken that they want a total exemption. And I don't believe that's what the right to know law is about. And I don't believe that we should take that entire class of records and just remove them totally from the public sphere. Because just as in the case I just mentioned, a lot of attorney work product in particular, and a fair amount of attorney-client interactions should be available to the public. So I think the balancing is very important, and that's why this bill.
Okay, thank you very much, Representative. Are there any questions for Representative Wolper? Seeing none, thank you very much. The chair will call Matt Broadhead.
Thank you, Madam Chair. With your permission, I'd like to share the stage here with Assistant Attorney General Christina Wilson.
Okay, just make sure that before each of you speak, you identify yourself for the record.
Thank you. Madam Chair, Matthew Broadhead, Senior Assistant Attorney General. Thank you, members of the committee, for listening to our testimony today. I'm here today with Assistant Attorney General Christina Wilson, and we're here on behalf of Attorney General John Formella, voicing strong opposition to this bill. I'll turn it over to Assistant Attorney General Christina Wilson.
Thank you, Madam Chair and members of the committee. I'm Assistant Attorney General Christina Wilson. And what I want to focus on is the exemption at issue touches on two very important concepts in our legal system. The first is the attorney-client privilege. And simply this is when a person seeks legal advice from a lawyer, those communications between them are confidential under this privilege. This protection provides a safe environment for people to obtain legal advice, and without it, clients may feel less likely to come forward, seek advice, ask questions, and be honest with their attorneys. It is considered one of the most sacrosanct and closely guarded privileges in the American legal system. It's deeply rooted in common law, and it's reflected in court rules, rules of evidence, and rules governing the professional conduct of lawyers, and they've been written this way to ensure that those communications remain protected. The second doctrine is the attorney work product doctrine, whereas the first privilege protects the communications. This doctrine is directed at the material created in anticipation of litigation. This allows for thorough preparation by attorneys without concern that others will obtain access to their work through discovery. These two protections apply in both the civil and criminal context, and they're both critical to providing effective legal advice and representation to our clients. The Department of Justice represents over 100 state agencies, licensing boards, and commissions. In addition to this, under RSA 99D, the DOJ represents individual state employees, officers, trustees, officials, including members of the general court, if they are sued for acts committed in the scope of their official duties. The DOJ also enforces criminal laws and prosecutes criminal cases throughout the state. In performing these legal services and providing legal counsel, DOJ's communications with its clients are no different in nature from communications that an attorney would have with their client in the private sector. Many of the agencies, boards, and officials that we represent come to us on nearly a day-to-day basis seeking advice and counsel. Just as with a private client, the privileges afforded to attorney-client privileges encourages our clients to come forward with ideas and be fully open with the Department of Justice. And in turn, this ongoing and open communication allows these agencies and our clients to better serve the state of New Hampshire. To provide effective representation, just like in the private sector, government lawyers need to be able to strategize and prepare their cases. Their impressions, their legal theories, strategies are entitled to the same protections as any attorney would have in the private sector. To deem otherwise would place government attorneys at an extreme disadvantage and significantly hinder the ability of the state to litigate both criminal and civil cases. And it's not just the state's clients that rely on these privileges to obtain effective representation. All public bodies, including the legislature, municipalities, they seek legal counsel from time to time, And those communications should similarly be encouraged, not chilled by fear that others are going to be able to access these private discussions. The existing exemption reflects what's been well established in common law, and that's that these protections are afforded. The protections afforded under the attorney-client privilege and the work product doctrine are just as critical to legal representation in the public realm as they are in the private realm. The existing exemption in 91A doesn't alter these protections, but essentially codifies what's been recognized for decades. The attorney-client privilege and the work product doctrine apply with equal force to government clients and lawyers representing those clients, and 91A as presently written appropriately reflects this. For these reasons, I'm here today on behalf of the Department of Justice and Attorney John Formella to strongly oppose any change to the exemption as presently written. I'm happy to take any questions.
Thank you very much for your testimony. Are there questions from the committee? Seeing none, thank you very much.
Thank you.
Okay, the chair will call Kate Morgan.
Thank you, Madam Chair and members of the committee. My name is Kate Horgan. I serve as the Executive Director for the New Hampshire Association of Counties, which is all of your elected and appointed officials. The association is in opposition to the bill. As the Attorney General's office laid out many of our concerns, the county's ability to have appropriate legal advice in a non-public session is very important. Oftentimes they're discussing personal information of their employees, and they do not think that that should be released to the public for everyone to see. We should be protecting our employees' rights. I also did just want to add very briefly that I did talk to several of the county attorneys, and no one can tell me what subject to the public's right to know means from a legal standpoint. They said it's very ambiguous and they wouldn't know how to apply it. With that, I will conclude my testimony, and I'm happy to take any questions.
Thank you very much for your testimony. Are there any questions from the committee?
Thank you.
Seeing none, thank you. The chair will call Margaret Burns.
Good afternoon. I'm Margaret Burns. I'm the Executive Director of the New Hampshire Municipal Association, and we are here this afternoon in opposition to House Bill 1073. As members of the committee know, last year, the New Hampshire Supreme Court issued a stunning decision that ruled that confidential attorney-client communications and attorney work product documents were not per se subject to disclosure, but instead were subjected to a balancing test with regard to the right to know law and a request for governmental records. In doing so, it overruled longstanding precedent and practice of municipal and governmental attorneys, which treated their municipal and governmental clients the same as their private clients with regard to attorney-client privilege and the right to confidentiality of their records and information. Fortunately, in the wake of that decision, the legislature took swift action to rectify the decision and amended House Bill 108 last year to make clear that records that are protected by attorney-client privilege and the attorney-client work product doctrine were per se exempt from disclosure. This legislation was supported by the New Hampshire Attorney General's Office, the New Hampshire Bar Association, the New Hampshire Association of County Municipal Attorneys, municipal officials, and the New Hampshire Municipal Association. House Bill 1073, as originally introduced, would have completely repealed the exemption that was codified last year by the legislature, but the bill has since been amended in the House, as referenced earlier, to state that the exemption is, quote, subject to consistent with the public's right to know. As such, the amended analysis of the bill states that House Bill 1073 now narrows the exemption as opposed to repealing it. However, the bill as amended is still deeply problematic and really, in effect, essentially does the same thing and repeals the attorney-client privilege. First, as you've heard previously, the terminology, quote, consistent with the public's right to know law, does not have any legal meaning. There is no definition of this terminology in the law itself, and there's no guidance for public agencies or public bodies when receiving a request of this nature for how to implement it. And for that reason, this ambiguity in the statute would certainly require litigation to not only interpret what the statute meant, but also on a case-by-case basis to determine how records requests should be treated under this law. Second, and even more importantly, despite the ambiguity in the bill, the intent is clearly to weaken or dilute the attorney-client privilege protection and the attorney work product protection. This would have a devastating effect on municipal and governmental clients and their attorneys by making them feel very cautious and very concerned about having frank discourse and discussions and receiving frank legal advice and guidance from their attorneys. This chilling effect would not be good public policy. I would also like to mention that the status of the case that's been referenced, the case from last year, in a very unusual turn of events, a number of municipal attorneys, as well as the New Hampshire Attorney General's office, had become involved and requested that the New Hampshire Supreme Court reconsider that decision. And in fact, the New Hampshire Supreme Court actually vacated that decision. And when this legislation was passed, when last year's legislation was passed, there was really no need for the New Hampshire Supreme Court to then reconsider that decision and put out a new opinion. So unfortunately, House Bill 1073 would essentially put us back in the position we were in before the legislature acted last year. For these reasons, we ask that the committee recommend House Bill 1073 as inexpedient to legislate. Thank you.
Thank you very much for your testimony this afternoon. Are there any questions?
Thank you.
Thank you. The chair will call Kathy Four from the New Hampshire Bar Association. Oh, it's Fox. Sorry, Kathy. You don't want to speak? Okay, great. The chair will call Josh Wyatt.
Good afternoon, Madam Chair. With
Good
me,
afternoon.
have with me Deputy City Attorney Jim Perez. With your permission, we may both speak to this.
Okay, and you are Jennifer Perez?
Yes.
Okay, just to remind you, if you're both going to speak, please identify yourselves before you speak, because then that way our secretary will be able to attribute the comments to the correct person.
If they could speak up, I was having some trouble.
Yeah,
Okay, thank you. I'm a little bit nervous. This is the first time I've ever testified on a bill. And I say that because I'm here because this is important stuff. When I say important, I mean I need this privilege and this work product to do my job for the city of Dover. We both do. We filed a letter. I'm not going to regurgitate everything in our letter. I just want to underscore, I think that this bill may be animated by some significant misunderstanding about the law. It is not the case that these are entirely exempt. I agree it's a per se exemption, but these doctrines are inherently limited. The attorney-client privilege has exceptions, one of them being the crime fraud exception. If an attorney is assisting someone in committing a crime or a fraud, that document is not privileged. Same for the work product. The work product is not an absolute protection. If someone has sufficient need for attorney work product, they can get it if they make the required showing. It is not the case that these things would never be discovered by the public. Attorneys are ethically bound. You may not, I'm sure maybe you do know. They cannot counsel people to commit a crime. It's in the rules of professional conduct, 1.2D. It says an attorney cannot counsel someone to commit a crime. What they do is help people make good decisions. And to do that, sometimes people need to be able to tell you the mistaken or misguided or bad idea they had in mind. They need to be able to tell you that so that we can tell them that's not such a good idea. And so I don't understand why we would water down the protection with this bill. And I believe that's its main purpose. To me, I think of policy decisions in terms of what is the upside versus the downside. I really don't see an upside in this bill. As I mentioned, these doctrines have limitations. there is significant downside. This is going to chill communications between public bodies and public officials and their attorneys, including maybe this body, if it engaged counsel. It will likely interfere with good faith efforts to comply with the law, and it will significantly disadvantage governmental bodies and officials in litigation, because the work product is meant to create a zone of privacy to prepare for litigation. Why would we allow people to discover that? It's just not in the public's interest. Sorry, I'm animated. I feel strongly about this. I don't know if anything you want to add, Jen.
Again, my name is Jen Perez, Deputy City Attorney for Dover. As Josh and the other speakers have reiterated to you, this is a hugely important bill and a hugely important issue. It affects how Josh and I are able to do our jobs and if we are able to be as effective as we are. The confidentiality of communications with attorneys and their clients is one that we're bound to. Our rules of professional ethics require it. It is a fundamental principle in the client-attorney relationship. It's crucial that our clients are able to come to us and ask questions free of the fear that those questions and those thoughts would be disclosed to the public. Also talked about today was the ambiguity of the amendment proposed. But what isn't ambiguous is what those privileges and those doctrines state. The attorney-client privilege and the work product doctrine are two separate and distinct doctrines, and they're both clear and narrow. And unfortunately, it's appearing as they're both being misconstrued in pushing forward support for this. It is hugely, hugely important that a clear understanding of what these doctrines are is had before decisions are made. I come to you asking that you please look towards these doctrines. Look into them, see for yourselves. I've submitted written testimony at the House. We've submitted a letter to you explaining what these principles are, how they are narrow, and how they're important to the work that we do. Maintaining these doctrines and maintaining these privileges is important for the public so that they can have confidence that their representatives are getting the best possible legal counsel. Unless there are any questions.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you both very much. Okay, the chair will call Chris Bolt.
Good afternoon, Madam Chairman, Senators. My name is Chris Bolt. I'm a partner at the law firm of Donahue, Tucker, Chandela, and I am here before you again. I was with you on Zoom last May in speaking in support of Senate Bill 95, which confirmed the attorney-client work product privilege in what is now 91A:5M. Previous to that, it had been our understanding that attorney-client work product materials were protected under the phrase confidential information in 91A:5 What we now have, because of the Hempstead case, was the legislation that you and the General Court adopted last year. I second the opposition of others that have been raised before, so I'll be brief. Briefer than some of my comments. That Hempstead case was the epitome of bad facts make bad law. You came in and you had something that had been shared with a majority of the board, and they didn't want to share it with the rest. That's one of those things. That alone was the issue. The trial court expressly did not reach the question of was that report work product. They expressly left it out. then they make some dicta. What we have before you, however, is a bill that only confuses the situation. And I ask that you kill it. We represent a myriad of private clients, individuals, and municipal entities. We represent about a third of the communities across our state. If we were to have a balancing test of how much is this document protected, is this not? Is this set of my notes on a particular file protected as attorney-client or attorney-work product? The bills to the municipalities, which are paid by all taxpayers, would be enormous. It is not one of those things we need to foist on our communities. Remember, however many folks are asking for something, there's an equal number of folks that liked the decision the selectmen were making. Let's not add to the bills of our municipalities. We ask that you recommend that this bill be ITL'd. I'm happy to take any questions.
Thank you very much for your testimony, Mr. Bolt. Are there any questions? Senator French.
Thank you, Madam Chair. Thank you for your testimony today. If your clients wanted this information made public, your work and all that, they could then release it without any problem to whoever's asking, correct? There's nothing keeping them from doing it.
Positively, Senator. The attorney-client privilege can be waived by the client. It cannot be waived by the attorney. And Rule of Professional Conduct 1.6 puts the obligation on us as attorneys to protect the confidentiality. And by the way, we do not have two classes of clients. We have the body of clients are all protected by the attorney-client privilege. And you who are lawyers on the panel and you who are business owners on the panel know that when you're going into a conference with your lawyer, that's confidential. You have that expectation.
Thank you.
Are there any further questions from the committee? Seeing none, thank you very much.
Thank you for the time.
Are there any other members of the public that would like to speak to House Bill 1073? Okay, seeing none, close the public hearing. There you go. Thank you. Thank you. You're all set? Okay. I'm going to go ahead and open the public hearing on House Bill 1343 and recognize the prime sponsor, Representative Gordon.
Thank you, Madam Chair. And members of the committee, for the record, my name is Ned Gordon and I represent Grafton County District 9. And I'm very pleased today to have sponsored and to introduce House Bill 1343. It creates a pilot program. The purpose of the pilot program is to determine whether under limited circumstances, certain non-attorneys may provide representation to litigants who are underserved in our court system. In particular, the bill would allow for a period of 2 years, qualified paralegals working under the authority of a licensed and insured attorney to represent clients in 3 types of cases in just 3 of our circuit courts. The first type of case would be family matters. And just by way of background, up until the 1980s, virtually all of New Hampshire litigants in divorce and custody matters were represented by counsel. But for a variety of reasons, perhaps most prominently the cost of hiring attorneys, the trend of self-representation developed, not just here in New Hampshire, but throughout the country. Now, 80 to 90% of the people who appear in our family division are unrepresented. The court has worked hard to accommodate this trend. It's established mediation programs and has attempted to make the legal process as understandable and as user-friendly as possible. But still, there's no substitute for legal representation. Unrepresented parties are clearly disadvantaged in our court system, especially when the other party does have counsel. Unrepresented parties are not familiar with court rules or procedures. Unrepresented parties are often anxious or intimidated by appearing in court. Unrepresented parties often make unnecessary concessions in order to avoid court proceedings. And unfortunately, unrepresented parties simply do not understand the law, which we seem to change here very frequently, and how it may apply to them. The financial cost of legal representation is often a bar to litigants, particularly in family matters. The hourly cost of an attorney may in itself be prohibitive, but the upfront cost of a retainer, particularly in family matters, often $2,500 or more, may make representation prohibitive. Even families of modest means, particularly when they're having problems in their family to begin with, may have difficulty raising that threshold amount at the time it's needed. The second type of case we're talking about is landlord and tenant matters. Roughly, and I might add that there are over 13,000 family cases filed in our circuit courts each year. With regard to landlord and tenant matters, 24% of all the circuit court cases are landlord-tenant cases. And currently, we are addressing a crisis with evictions. Tenants tend to be less affluent and are unable to afford to be represented in those proceedings. And I have no doubt that many people are evicted in the state simply because they do not understand the process or understand their rights. And finally, domestic violence matters. We have approximately 4,600 cases each year on domestic violence petitions filed in the state. I'm offering an amendment today to add domestic violence. The original bill which I filed only included landlord-tenant matters and family matters. But I recently read the results of the Domestic Violence Task Force. And in reading the report it produced, it indicated only 13% of alleged victims are represented by attorneys. And frankly, from my experience in the court, I think that's a high number. Accused abusers are far more likely to be represented. And this provides alleged victims with a substantial disadvantage. And if I could just summarize the conclusion of the report is alleged victims need more than just a hand, they need a voice. The amendment would allow for non-attorneys to represent clients in domestic violence cases in the pilot courts. Having non-attorney appear in our court is not entirely new to us. In fact, there's a statute, New Hampshire statute, that specifically provides that a person appearing in our courts could be represented by a person of their choice. But we have, however, imposed limitations on the practice of law, including how many times a person may appear in our courts and whether they can be compensated. Currently, we allow police officers to, but at the same time, we allow police officers to prosecute cases in our courts without any requirement for legal training. We allow domestic violence advocates to assist litigants in court, even though they do not speak on their behalf in court. Non-attorneys are representing clients in hearings, administrative hearings, particularly before Health and Human Services. And non-attorney guardians ad litem appear regularly in our circuit courts. If enacted, the pilot program would be limited to 3 courts. And again, I have an amendment today. The amendment, which also adds domestic violence, also adds in the Franklin Court. What we did initially was we picked 2 courts, the Manchester Court and the Berlin Court, a large court and a small court. But after consideration, we're concerned that the number of cases in the Berlin court wouldn't be sufficient to provide us with the type of results to know whether or not the program was successful. So we've added in the Franklin court as an additional court. So there would be 3 courts subject to the pilot program. The pilot program would be in place for a year. Non-attorneys would work under the auspices of a licensed attorney only. They would meet certain qualifications, educational qualifications, and experience qualifications in order to qualify. And that attorney that they're working for would have to be insured. And Franklin in particular has a substantial need, and being closer to the population centers of New Hampshire will provide more cases to evaluate the pilot. I'm aware, that I'm aware of some of my colleagues who may be members of the bar who may object to this idea of having non-attorneys represent clients, and they may express the concern that the public may not be well served. I got to tell you that if you asked me this 20 years ago when I was a newer attorney and you said, do we think let non-attorneys practice at all in our courts, my answer certainly would have been no at the time. I've been to law. I went to college for 4 years. I went to law school for 3 years. I had debt that I incurred in order to become an attorney. I had to go through the bar examination. And I don't want somebody else who didn't have to do those same things do the job. But the question really comes down to how we're going to serve these people. The bar has known about this problem for a long time. In fact, it published 2 surveys. One was done by the Bar Foundation back in 2013, which was called the Justice Gap. And it's really an extremely well done document explaining how people are underserved in this because they do not have proper representation in our courts, and they need more representation. And they published a second document just last year on the Access to Justice Committee on a report on access to justice. And in its executive summary said that New Hampshire has a shortage of low and no cost legal help, and services should be expanded so that people can get the help that they need. If I was looking at it and saying, are we concerned about the quality of service that we're providing? If we're not providing any service, I think on balance, if we can provide better service to the people of the state, we would be doing well if you're doing a balancing test. This bill again provides for the pilot program. It'll be done on a limited basis. It'll be for two years. I might add that having non-attorneys is a trend that's going across the country right now. It isn't just unique to New Hampshire, although I think we would be somewhat on the leading edge in this particular thing. It's very analogous to the medical profession where we've seen in recent years the development of nurse practitioners and physician's assistants, and I believe a program of the type can work in New Hampshire, just as we do. And finally, I guess the last thing I'd like to add is this isn't a panacea. If we did this and we were able to provide non-attorney representation, I don't think it's going to eliminate the concern at all of unrepresented people. I did note that in the survey that was done just last year, in the survey that was done in 2013, they did a survey of court personnel who daily deal with unrepresented people, and they asked a question, and that was, why don't self-represented litigants? Why don't self-represented litigants have attorneys? And 92% of the court personnel said it was mostly because they couldn't afford them. 92%. And they also, and I think this is very important, said that 61% of the people they see, they agree that 61 have lack of reading or comprehension skills, which is why you really need an attorney to be able to represent you and to speak on your behalf. So again, I don't think it's a panacea, but there are other reasons why people might not want to be represented by an attorney, but I believe that this has the potential to benefit many, and I ask you to consider this legislation and hopefully pass it.
Thank you very much for your testimony, Representative. Are there any questions from the committee? First, Senator Khan, then Senator Gannon.
Thank you, Madam Chair. And I've got several questions in different parts of the bill. And Chairman Gordon, nice to see you. So I'll start with some of the easier ones. The implementation date, every time we get something from the courts about implementation dates, I always say January 1st of whatever year. Do you have a strong preference? Because all these dates are July 1.
I do. Well, the amendment, originally I indicated it would be January 1st. No, I don't have a, it would be July 1st of 2022, I believe, is the effective date.
Yeah, I didn't, that, right.
So, no, I don't have a strong preference. If it took some time to implement, that would be fine.
So if that was a January 1st, then you just want to slide the 2-year period out to December 31st of 24.
Right. Well, right now, the 2-year period runs from July 1st of 2022 to July 1st of 2024.
Right. So you'd want to make sure we had 2 years.
Right. We'd want to make sure we had 2 years.
Yeah. That was the easy one.
No, not easy for you.
Yeah. And I appreciate what you're trying to do here. And I wanted to make sure that I heard you correctly, because I think I missed it. In the family courts, you said 80 to 90% of the cases are unrepresented?
Self-represented litigants. In many cases, it's both parties.
And Madam Chair, just to continue with that, actually, now a different thought. I went to RSA 311 to look for the reference to paraprofessional and licensure, and that's why you've defined it in here. It's not there. And so I'm wondering, how are the folks, I see the qualifications.
Yep.
But is there any certification? Do you envision, this is just any attorney licensed in New Hampshire to practice can designate this paraprofessional status to somebody under their supervision who meets the minimum qualifications in this bill?
That's correct. But they have responsibility for them and their conduct.
And any charge of misrepresentation would be subject to the liability of that supervising attorney.
That's right. And I'll tell you why it's being done that way from my perspective. Other people may comment on that. But they have tried to have these programs in other states where they have gone through the complex certification or process and have found that it hasn't been that successful, because to that extent you make the process onerous. And so what we've tried to do is streamline the process so that it works. I can tell you that virtually any attorney who's had a paralegal work for them for a substantial period of time will probably tell you the paralegals are doing their pleadings for them now. They're doing virtually everything that the attorney does in the office. But the only thing that they can't do is in theory, provide legal representation or go speak on their behalf in court. And so I believe that I don't, for any reason, think there needs to be a formal certification or registration process.
Maybe I said that once before, but the income limits here, I could see. I guess I I'm just 300% the validation of, was it 310 or, so what do you envision as the process? Because this is either for a family court case, a landlord-tenant case, or a domestic violence case. Just what kind of evidence is going to be presented by the client, reviewed by the paraprofessional to assure that compliance with the 300% is met?
Well, I worked with legal assistants to put this together, and I'm presuming that most attorney, I think if we do the pilot, what you're going to find in most cases is that you're not going to find private attorneys going out and hiring paralegals to do this type of work, frankly, because you have a pilot with a 2-year window, and I don't know that anybody is going to find themselves committing themselves to that type of expense and that type of obligation. What is going to happen, I believe, under the pilot is you're going to have organizations like New Hampshire Legal Assistance, who is already using paralegals to represent people in hearings, administrative hearings. And they are the people who are going to be doing this type of work, or 603 legal aid, perhaps. Or maybe even the coalition might want to do that. They have advocates now, but potentially I could see them in a position where they might be able to do that and provide that type of assistance to domestic violence, alleged domestic violence victims. So I think that's the way I envision the program working, at least the pilot working. And those organizations are already currently accustomed to making that type of financial assessment.
Thank you very much.
Thanks, Senator Gannon, then Senator French.
Thanks for taking the questions. So I'm concerned, so you get the feeling that, and I agree with you, some representation, better than none. But I don't want to send out the message either that New Hampshire poor people are going to get overqualified. And I'm just very concerned with work experience, 2 years. If you went to law school, college, you really have a long background. Much more complicated. I'm involved, let's say, in a domestic violence issue, right? I could lose custody of my children. I could get jail time. So to me, these are such serious matters. I would rather the experimental part of this be not in the domestic violence issue. Just see that that's really important. Going too far. Having non-attorneys with 2 years of work experience in a way.
Yeah. Well, how many family law courses did you have in law school?
I had a lot. I was very involved in the case.
Yeah, I can tell you that, I certainly didn't. And I know many law students go through the entire law school and don't have any experience in family law and those particular issues. You do get certain training that's important in terms of logical thinking and the things that you get in benefit in law school. I can tell you that what my experience having done family law, but having no training on that in law school certainly, was that I learned from experience.
Thank you.
Senator French, then Senator Whitley.
Thank you, Madam Chair. Thank you, Senator Representative. In regards to opposition, like you just got from the Senate to my right, could you tell me, why do people believe it always takes someone with a law degree to interpret laws written by non-lawyers?
I can't tell you the answer to that. I can tell you that 3 years ago, I found out I had cancer. So, I have the best oncologist in the world, just wonderful person, love her. But the person who discovered it was the physician's assistant, discovered I had cancer. Then I went through months of chemotherapy, and it was all coordinated with the physician, with the nurse practitioner. And the oncologist supervised all of that and said hello to me once in a while. But I don't think I needed that oncologist to do all the things that needed to be done. And I think that's sort of what's here. I think if you have an attorney supervising, I don't think you need the attorney to do everything that needs to be done as long as that attorney is making sure that that experienced person is doing their job well.
Great, thank you.
Senator Whitley?
Thank you, Madam Chair, and thanks for taking my question. And thank you for bringing forth this bill. I'm also a co-sponsor. So I do think, just addressing what Senator Gannon, raised, the issue of, are we sending a message to folks that perhaps are lower income about the quality of services? But I'm wondering if you can address, sort of this balance. Is it better for them to have a paralegal, or is it better for them to have no representation at all going through these things?
Well, it's not a question for me. We have, I can tell you that I sat as a judge for 13 years. I was one of the first judges to volunteer to be a judge in the new family division, and sat in family division cases. And time again, you would see people who would come into court, and it was frustrating. Frankly, it was not what frustrating for me. It was frustrating for attorneys that were in court having to deal with pro se litigants who basically were, and the word I use is disadvantaged, because they didn't understand the law. They sometimes wouldn't comply with the law. It was difficult. And frankly, having anybody represent them that's experienced, knowledgeable, knows what they're doing is going to be better off than having them be on their own. Going to court's intimidating. Just to have somebody with you that can speak on your behalf makes all the difference in the world.
Follow up?
Yes, follow
Apologies, I missed the introduction of the bill. We are double booked here in the Senate this morning. And if you had already said this, excuse me, but do you have the numbers about those that are going through these proceedings unrepresented?
That unrepresented, in the family division, it's 80 to 90%. The vast majority of people in landlord-tenant cases are unrepresented.
Okay, thank you.
Okay. Are there any further questions? Senator Gannon?
Just one more quick thing. I don't know in New Hampshire, you can tell me. When I was a million years ago, first a lawyer in Mass, I probably had 2 years, and I got a certificate so I could practice. I don't know if it's done up here at all. And so at a 2-year point, I was allowed to go to court and practice as an attorney, with an attorney watching me and shadowing me a little bit, but maybe not in court with me. Would we be better served with someone with a 4-year degree, 2 years of law experience, just because maybe we learned something that the good senator didn't realize that we do learn in law school, so you do a better job? Is there such a program in New Hampshire?
Do we have such a program as?
Like at 2 years, after 2 years of law school, you can take a certificate, when I'm getting nods in the back that we do. That you could practice law at 2 years under supervision before you get your degree, a year ahead.
Yeah, we have what's called Rule 36.
Okay, and there's not enough of those young budding attorneys? No.
We do have Rule 36 students. I certainly was one at one time, so.
Okay, thank you.
Okay, are there any further questions? Seeing none, thank you very much, Representative.
Thank you, Madam Chair, members of the committee.
The chair will call Chief Justice Gordon McDonald.
Good afternoon, Madam Chair, members of the
Good
committee.
afternoon.
For the record, I'm Gordon McDonald. I'm Chief Justice of the New Hampshire Supreme Court. I will be brief. I know the committee has a lot on its agenda today. But I did want to come over and appear personally on behalf of all of my colleagues and express our strong support for House Bill 1343. I commend Representative Gordon and the Senate co-sponsors, Senator Whitley and French, for their leadership on this. As you heard from Representative Gordon, every day in our circuit court, scores of our fellow citizens appear without the benefit of representation. And they're in court invariably because they've experienced some life-altering event. They may be facing an eviction, a custody dispute, or an incident of domestic violence. And potentially at issue are their basic human needs, their safety and security. And yet they're standing there alone in a foreign, in an unfamiliar territory without the benefit of representation. As Representative Gordon just said, up to 90% of litigants in our circuit court appear every day without representation. Last year, in 2021, 13% of plaintiffs in domestic violence cases had no representation. And I believe this bill will not only add, the amendment that Representative Gordon has not only adds domestic violence, but stalking. In that class of case, 5%. 5% of plaintiffs in stalking cases in 2021 had no representation. That defines the access to justice gap. It's an issue that ultimately affects us all. And we need to come together to address it. And that is what makes this moment so important. This pilot, this experiment that, if approved, we would embark on is one of the most meaningful steps that our state will have taken to address the access to justice issue. In permitting qualified paraprofessionals who are subject to the supervision by attorneys to appear in certain classes of cases, we will take a very important, albeit incremental, step to addressing access to justice. Fewer of our fellow citizens will be there standing alone on a very important day in their life. If approved, the Supreme Court stands ready to take the steps necessary, including rules changes to make sure that there's an proper implementation, as well as to monitor the success or failure or areas for improvement in this pilot program. Madam Chair, members of the committee, thank you for your time and your consideration, and I respectfully urge that the committee approve House Bill 1343.
Thank you very much for your testimony. Are there any questions? Senator Whitley and Senator Gannon and Senator Khan.
I'm good. I already know how.
Thank you, Madam Chair, and thank you for taking my question, Chief Justice. And actually, it's not a question, it's just a comment. You know, I think it says a lot about your commitment to access to justice by being here and testifying in front of us today. So thank you for that.
Thank you, Senator.
Okay, Senator Gannon.
So I think you probably heard my concerns before in certain issues like a domestic violence case where you could lose custody at jail time. What if you just had your trial court limited? There were other areas. There were 2 other areas besides domestic violence cases, I believe they said they could hear. So these maybe issues where you're not losing your custody, you're not losing your physical custody of your body to the system. Couldn't we start this in a maybe less important area than losing your children or physical? Just that domestic violence issue and someone going to jail because they had a 2-year degree person who's not really qualified. I'm scared that they're pretty good, they're better than nothing. I want to give them better justice than that.
Well, let me make a couple of observations. First of all, protection of the public is very important to us. And there are multiple layers of protection of the public in this bill. The first, of course, is that the paraprofessional will be supervised by an attorney. The second is the requirement that the attorney retain professional liability insurance. And the third is, as you know, Senator, at the end of the day, under Rule 5.3 of the Rules of Professional Conduct, we as attorneys are responsible for the competent undertaking by all of our colleagues in our law office. I would urge the senator respectfully to take a look at the judicial branch's report on domestic violence and the lack of representation. And I will just respectfully suggest, Senator, that people in that situation should not be standing alone in court on that important day with those important rights at issue.
Follow up?
I would much rather have you on my side than someone with a 2-year degree. And so I feel we're going to have two systems of justice, which maybe we already have, and maybe this is a slight improvement. But I would much rather you on my side than the 2-year person who sort of has a related experience in the law.
Well, if I may,
Sure.
Senator, walking into court, even for trained attorneys, is a nerve-wracking experience. I mean, I still get butterflies in my stomach, not necessarily now, but I did as a practicing attorney.
Sure. I'd get them if I had to go in front of you. I'm all set. Thank you.
Okay, Senator Khan?
Thanks, Madam Chair. And it's a delight to see you here today. And I agree. The importance of the issue is highlighted by your presence. So, two questions. Clearly, you've made an argument about quality, and I think so did Representative Gordon. Will this also help court efficiency?
No question. I think you heard a little bit of this from a 13-year veteran of the circuit court. Inevitably, when someone is self-represented, there are inefficiencies that result. I mean, our judges do their very best, but it is not the same. And so there are inefficiencies that result from dealing with self-represented litigants.
Because judges are educating from the bench and
doing their best.
And
within the rules of conduct, yes.
Gotcha. And a second thought, we've heard concerns about amount of training, whether you're licensed by the bar or you're a 2-year college graduate. Would we benefit by having our colleges, universities in the state observing alongside this pilot that the programs that we have might prepare more students to provide this kind of, feed that interest with education that would prepare people to provide this kind of professional service.
That's an excellent suggestion, and particularly our programs which are training paralegals, yes.
Do we have such programs in the state?
To my knowledge, no. But I'm not sure, but I don't know.
I think maybe the University of New Hampshire does, but I think...
Do we have training programs for paralegals? Yes, there are such things, but whether they incorporate going to court on these cases, I don't know.
Family law, assault, and domestic violence.
I don't know that.
And landlord-tenant. Okay, well, thank you very much.
Are there any further questions? I have a question. Sorry, I know you probably want to just run away from us, but I noticed here it says that the Supreme Court may promulgate such rules as necessary to regulate the conduct of paraprofessionals. Do you think it would be advisable for the Supreme Court to adopt a rule that after, I don't know, 2 years, you issue a report so we can know how this is working, what you're finding? I think that something like that would be appropriate. And I know that I would be interested in seeing how this is working and what the reaction from the attorneys are, even their the clients and people that are appearing before the bench. Do they feel that they receive justice by having this paraprofessional instead of not having anything at all?
Madam Chair, I think it's an excellent suggestion. I would personally suggest you put that into the legislation and rather than us do it by court rule. And I as the Supreme Court would be prepared to undertake that.
Okay, terrific. Thank you. See, now this is what happens. Senator Khan.
I want to, I'm not sure if we're going to get somebody from the judicial branch testifying. And this question about implementation date. It says July 1 currently. should we be looking at that further to see if the implementation date is better suited for a January 1st date?
I think there will be some modest rule changes, so we'll make it happen if it's July 1st, but if it's extended by 6 months, that would give us that much more leeway.
Thank you.
Seeing no more questions, thank you very much.
Thank you, Madam Chair.
Okay, next we have Lynn Charlotte.
Good afternoon, Madam Chair, members of the committee. My name is Lynn Charlotte. I'm the Executive Director at the New Hampshire Coalition Against Domestic and Sexual Violence. We are here in support of House Bill 1343 and specifically in support of the amendment that was introduced today, because it will expand opportunities for victims of domestic violence who are seeking protective order to have legal representation. Protective orders are such essential tools for victims to gain relief from abusive partners and to ensure that they and their families can be safe. And I know that you will hear more today from New Hampshire legal assistants about the excellent services that their paraprofessionals currently provide to victims of domestic violence. So I'd like to address briefly the need and the impact this representation will have. As you've heard today, there is significant unmet need for legal representation in domestic violence cases. As the Chief Justice reflected, less than 13% of victims who are seeking a restraining order in a domestic violence case have representation, and less than 5% in stalking cases. And that means representation at any point during the process. So even if they do have representation, it could just be a consult for drafting a petition or representation at a single hearing. A victim of stalking or domestic violence has already experienced terrifying, often life-threatening trauma, and then they enter a foreign system. They don't take this process lightly. It's lengthy, it's emotional, and it's a difficult process to file for a restraining order. And victims are asked to relive their trauma over and over when they fill out the paperwork and then when they testify in court in front of the abuser. And they very carefully weigh their options about whether to even pursue a restraining order. As a result, expanded legal representation will have a significant impact for victims. You've heard a little bit today about the recent task force that was convened by the judicial branch, and the underlying case that led to that is an example, an important example about why we need added legal representation. What we hear every day from advocates at our crisis centers is that it's becoming ever more difficult for victims to draft petitions that meet the evolving legal standards to receive an order. When protective orders were designed, they were created to be accessible to victims who do not have legal representation. But that's become more and more difficult in the process. Victims now have to allege not only that they've experienced abuse, but also that they are in immediate danger. Unfortunately, what that means is that on a daily basis, we see victims who may have physical injuries, but still are denied a restraining order. In fact, what we know from statistics in New Hampshire is that only 38% of petitions for final orders are in fact granted. So having a knowledgeable legal professional vastly improves the likelihood that a victim will present an effective petition. Lastly, I'd like to address a question that came up earlier about advocates and attorneys. Victim advocates at crisis centers throughout New Hampshire serve approximately 15,000 victims a year. What those advocates do is provide information, emotional support, options, accompaniment. They are familiar with the court process. They present victims with all of the options they have moving forward, whether that's to go to the hospital, to report to police, or to engage in a court process. And they explain to victims what to expect in each of those processes. But what they don't do is step into the shoes of those professionals. They're not police officers, they're not lawyers, they're not sexual assault nurse examiners. So what's truly optimal is to have a victim advocate and also to have a legal professional working with victims. So we urge your support of the underlying bill and the amendment. Thank you. All right. Sure.
So again, thank you. Again, it's my fear that you could have, you're saying a legal professional, and I do want you to have legal professionals by your side. I'm in fear that you're going to have a young 20-year-old person who had very little experience. Maybe they're under the tutelage of a competent attorney watching them over. Maybe they're not. I'm very fearful, again, someone going to jail, losing child custody because they had a 20-year-old by their side who has a background in law at their 2-year degree.
Thank you
It's
for your,
scary to me.
I'm sorry. Thank you for your question, Senator. I think that there are a couple of aspects of this to look at. One, you mentioned going to jail. I don't believe this applies in any criminal cases, so that's important here.
Am I wrong? Does it apply to?
Reflects the criminal process.
Oh, that it would include the criminal prosecutions?
Yeah.
Okay, we can follow up on that with you.
Okay.
That being said, otherwise victims would be going to court completely on their own without the guidance and without the advice and input. And we have seen programs across the country where paralegals develop a very high level of specialized expertise in giving that advice. And we believe that would be more beneficial than a victim going to court on
My
their own.
quick follow-up would, if I took away things of that nature, of a criminal nature, where someone could lose custody, where they could go to jail, if I had a tighter scope of the cases that these people could hear, I would be more comfortable. These are just such huge issues to me. Again, to where you possibly could have a young 20, I can picture I have a 20-year-old. She should not be by someone's side as there, and she's have a lot of legal background. No, I just don't see it in certain cases. I like a test program where it's a little less dangerous to me than putting someone's life and liberty in jeopardy.
I appreciate that, and the reality is that most of these victims are going to court completely unrepresented and without any guidance, and so we believe
I'm
that
appreciative of that. Okay,
with the appropriate oversight that this is an important expansion.
I am great. Thank you. Anyone else? Thank you very
Thank
much
you
for
so much.
testifying. Mattson Dustin, come on down. Good to see you today.
Nice to see you too, Senator, and good afternoon, everyone. My name is Sarah Mattson-Dustin. I'm the Executive Director at New Hampshire Legal Assistance, which is the state's oldest and largest civil legal aid provider. So it is my job to worry about how we can get access to legal services for people who have low income. We have 20 lawyers and 5 paralegals. It's because of what those paralegals do day in and day out that I enthusiastically support this bill as well as the proposed amendment. Our paralegals do work including certain kinds of immigration cases, unemployment insurance appeals, appeals related to Department of Health and Human Services benefits, Social Security disability appeals. It is highly technical work that is often both substantively and procedurally complex. And although I am, as a licensed attorney, permitted to handle all of those proceedings and more, I can assure you that any one of them would clean my clock, because they know what they're doing based on many years of experience. And I am confident that the training and supervision structures that have supported them in being able to do that work can be effectively deployed in the courtroom setting as well. They are permitted to do all of those proceedings now because they are either administrative law proceedings in which a person can have any representative, or because they're administrative law proceedings in which there are specific kinds of accreditation for non-lawyers, as is the case in the context of Social Security disability and certain kinds of immigration proceedings. A couple of other states have experimented with this and have generally gone the route of independent paralegal licensure. So basically setting up a different regulatory regime for people to be able to set up shop as non-lawyers. This is a totally different approach. This is leveraging our existing, very comprehensively regulated profession and saying the ethical requirements that bind us in terms of supervising junior attorneys and supervising non-lawyer assistants can be used in the courtroom as well, which right now has this sort of magical invisible line around it that says, beyond here, you may not pass. This is where we think only lawyers can do the job. So I think that I think it's a good way for New Hampshire to experiment with this concept. It's a very tightly regulated regulatory sandbox, if you will. Now, I did want to address Senator Gannon's good questions about whether this applies to criminal proceedings. So RSA 633:3-A is actually kind of a funny statute. It's in the criminal code, but the right to petition for a civil stalking order is embedded in it. The proceeding, though, for a civil stalking order is in either the family division or the district division, and so the circuit court criminal division is not included in this bill. So if the committee wanted to clarify further that it is intended to apply to domestic violence protective orders and stalking protective orders, and not to criminal stalking proceedings, that certainly would, I think, be fine with everyone. That's absolutely what's intended. It's a little bit unusual in that the civil right is embedded in the criminal statute. So the way that I read it, and certainly the way it was intended, was for this only to be for civil proceedings. And that's because in a criminal stalking case, you have a right to a lawyer. You will be assigned a New Hampshire public defender or appointed counsel outside of the New Hampshire public defender system. I think that's really all that I wanted to share. It's tough to follow Judge Gordon and the Chief Justice, but I'm very happy to answer any questions that you have.
The civil part, you just made that much more clear for me. Go ahead, Senator Price.
Thank you, Mr. Chair. Thanks for showing up today. Just one question. So these paraprofessionals will be working under an attorney, and that attorney shall carry professional liability insurance with reasonable coverages. Is there such a policy that will cover your paralegals working in the courtrooms today?
So that's actually an interesting question. So the policy covers the firm. So if, for example, a legal secretary makes a mistake, that is an event that can trigger coverage under a professional liability policy. We are, for our policy, we're required to disclose every year all of the attorneys and the number of staff working generally. I think it'll be an interesting question to see if the professional liability coverage market responds in any way to this, but right now we have paralegals doing lots of other things that would be considered law practice, but for the fact that they don't occur in a courtroom. And our supervision responsibilities entirely extend to that work. We aren't excused from supervising non-lawyers because they're handling an administrative law proceeding as opposed to being in the courtroom. So essentially for everything other than being inside the courtroom, this is already the law.
Yeah.
Those folks are already authorized to do work so long as they're being supervised. We cannot, we're required to discharge that supervision responsibility regardless of the setting.
So you think it'll cover it?
I think that our policy already covers it now.
Yeah.
I'll be interested to see if they want to charge us a little more because they can go to court.
Okay, thanks.
Senator Khan, go ahead.
Thank you. Thanks for being here. Because you're going to be implementing this program, and that's it's good to have the link to an agency that really has a stakeholder interest. So one of the things here is that we're using the term paraprofessional as opposed to paralegal. And I think you might have sorted that out for me in your testimony, but I wanted to make clear, because I think many people understand a paralegal's training. There's an implication about kind of maybe a degree that a person has, and you're avoiding that by using, is that the sense of trying to separate from something that has a more acknowledged terminology?
Well, here in some states, having the title paralegal has something behind it. It may mean that there's a certificate program that someone has completed, or in these states that have done these paralegal independent practice experience, there's a certification process that's administered by a licensing board like we have for many other professions in New Hampshire. So I think the word paraprofessional here is intended to make the qualifications within this bill be what qualifies someone as a paraprofessional, whereas someone who you're not required, for example, to have gone to a paralegal program for your education in order to qualify as a paraprofessional on this bill, under this bill, but many people have done so. And so it seems a little bit confusing to me to use the term paralegal because that is a term of art in some places. It refers to a certain kind of education, even here in New Hampshire, although there's no necessarily regulatory regime that says this is what must be included in a paralegal program, at least to my knowledge. And those are not programs that are offered by New Hampshire's law school. So it's intended to make it more specific to the content of this particular legislation.
Thank you. And then on line 28 of the bill, we've got the New Hampshire Rules of Professional Conduct, particularly Rule 5.3, pertaining to the responsibilities of non-lawyer assistants. What is that rule?
Sure. So these are in the attorney's ethical rules, which are the rules of professional conduct, which are New Hampshire Supreme Court rules. And it requires, it uses the language of law firms. So forgive me for that. We know how to apply it in our non-law firm setting, but each partner and any other lawyer who has supervisory responsibilities is required to make reasonable efforts to ensure that a person other than a lawyer who is providing services is doing so in a way that's compatible with the lawyer's professional obligations. And there are certain specific circumstances under this rule which would make a lawyer specifically liable for an ethical violation. Now, keep in mind that this is an ethical rule. So what hangs on this rule is whether or not you can face professional discipline in the attorney licensing system in New Hampshire. It is totally different from the concept of professional liability. So the distinction is that if, just to give you a simple example, if I am aware that a non-lawyer in my office has committed an ethical violation, let's say violated attorney-client confidentiality. You've had a word salad of attorney's ethical rules today. If I know about that and I don't immediately remediate it, or if I direct it, then I am on the hook for that ethical violation. My license is at risk. If someone makes a mistake, the firm is liable. Does that make sense? So the difference between liability and sometimes there are very often situations in which you're liable for an error and there's been an ethical violation, but all law firms make mistakes occasionally, and that's why we have professional liability coverage, but lawyers aren't responsible for, the professional liability is much, much, much broader than an ethical violation.
So this rule is not covering professional liability?
This specific rule is not, but there are a variety of other ethical obligations that extend, for example, to the competence of the representation that you're providing. So the rules work as a network of overlapping obligations.
Thank you.
Sure.
Thank you, Mr. Chair. And thank you again for being here today, Sarah. So as I said to the Chief Justice, I just want to thank you for your agency's commitment to access to justice. By the numbers, it sounds like we have a crisis in terms of access to justice. And so, I just wanted to thank you for your work day in and day out for bridging that gap.
Thank you. And even though that wasn't a question, I hope I can answer it and say, what I would like to leave you with is that even within the very small universe of civil legal issues impacting basic needs within which we practice, we turn away a dozen or more people every week who need our help, who are eligible for our services, who have meritorious cases, who we just can't help. And so you're right, Senator Gannon, we already have two systems, and this would go just a little way towards leveling those out.
Attorney, thank you very much. Always clear, concise, and to the point.
Thank you.
Okay. The chair will call, it looks like Mark Rudolin? Close, okay.
Did a nice job reading my lousy handwriting. So.
I thought only doctors had lousy handwriting.
No, not limited. Good afternoon, Senators.
Good afternoon.
My name is Mark Ruvalis. I'm a trial lawyer and a partner at McLean Middleton, and I'm here to speak in favor of House Bill 1343. I will shorten my comments to echo those of the previous speakers in favor of it. For all the reasons that they expressed, I think this is an important step forward. In addition to my private practice and my role for my firm, I've been a pro bono volunteer through the New Hampshire Bar Association for the past 30 years or more that I've been in private practice, and strive to meet the ethical recommendations of meeting 30 to 50 hours of pro bono service a year. And even when you do that, and even with the
hundreds and thousands of other lawyers in the state who volunteer their time to help the administration of justice, we still are short of people to provide direct representation to individuals in need in these extenuating circumstances of housing and personal safety and food and shelter. I also am co-chair of the Supreme Court's Access to Justice Commission. We, as a commission, took a sense of the commission, not a formal vote, because we are made up of both members of the judiciary who couldn't vote on something like this or express an opinion in favor of it, but the private practitioners from large firms like mine to small firms and organizations like New Hampshire Legal Assistance were all, the sense of it was to be in favor of this as a small step forward to try and improve access to justice for those in need. There are a couple of questions that Senator Gannon has been asking appropriately, and Senator Khan too, about responsibility. And one of the key things here about the legislation is that it requires attorney supervision. And in my firm, I am responsible for everything that happens on my cases under my direction. In fact, I'm responsible for my other 32 partners as well, or 35 partners as well. And if you think about it in that way, this bill doesn't change that obligation of the attorney to provide that level of supervision and make sure, to your questions, that people who are inexperienced or getting experience have sufficient training and support to provide the services that are being provided. We all do that. We all start out somewhere with no experience in a particular matter, and then move forward based on our experience and training and efforts we make to educate ourselves and from the support that we have from others with whom we work. The same holds true here. And so I think this is an important thing. It's an important experiment to improve access to justice. And we've come a long way in this state. I mean, I've been involved over the course of my career in these access to justice issues, and we've talked about the hierarchy of preference for providing services to those whose need. Of course, individual representation by an attorney, in our view, is always the gold standard for helping people out. But the numbers are just overwhelming, and that can't be accommodated. So we have 603 Legal Aid that provides telephone advice. We have the legislature allowed a pilot program for court navigators that's being dealt with now and implemented now to try and get people information about their rights and duties and obligations in the court system. And I would not overlook the benefit to the court system itself of having someone help people process what can also always be an important, a complicated and intimidating situation. It smooths that out. The courts do a remarkable job of trying to administer justice fairly, even to those who are unrepresented. But having someone there to help tell the story, help meet the obligations of the court, makes it a better system for all. Thank you very much for your consideration of this bill, and I commend it to you to pass. Thank you.
Thank you very much for your testimony. Are there any questions from the committee? Okay. Seeing none, thank you. Are there any other members of the public who would like to speak to House Bill 1343? Seeing none, we'll close the public hearing. Yeah. Thank you. Oh, one person. Okay. Only one? Okay. Okay. You're all set? Okay. we're going to go ahead and open up the public hearing on House Bill 1448 and recognize the prime sponsor, Representative Lynn. Good afternoon, Representative.
Good afternoon. Thank you. I sent you a text earlier because I was afraid that I was going to be late, but it turned out
It always works out. We're always.
my hearing ended early also, so it was worked out well. Thank you, Madam Chair, and members of the committee. As I'm sure you probably are aware, this bill is the ultimate sort of inside baseball. I'm sure if you ask, is there a great public interest in this bill? People would say, what's a pre-terminated heir? But I do think it's important. And I should say at the outset that the bill that you have before you was amended in the House, and it represents input from a variety of probate law practitioners in New Hampshire who made pretty significant changes to the original bill that was as drafted, and I was very glad for their input that they did it. If I can ask before I forget this, because this is critically important. One of those practitioners mentioned to me that as the bill was passed by the House, there's actually a typographical error that I hope you'll be able to correct before it comes out of the Senate, assuming you decide to pass it. And that is on page 2 of the bill, under Roman numeral 3, where it now reads, neither paragraph 1A or B shall apply. It should actually say neither paragraph 2A or B should apply, because when it was originally drafted, there wasn't what is now subsection 1. There wasn't the definitional section, and so that was the by adding that, we moved what was 1 down to Roman numeral 2, and so that's the section that should not apply under the circumstances specified in Roman numeral 3. Is that?
We got it.
Okay.
Okay. So we're good.
Okay, great. Thank you. So this bill is designed to change the current pre-terminated heir statute, which operates or can operate, I guess I should say, pretty harshly in a couple of ways. And the first thing is, under the current statute, the pre-terminated, it applies in basically 2 circumstances. One, where a person makes a will and then after making the will has another child. And the theory of the statute is that if in that circumstance, if you haven't, unless there are some other circumstances that I'll talk about in a minute, but in that circumstance, you've probably just forgotten to change your will around to accommodate the fact that you now have 3 children instead of 2 or whatever. And that makes a lot of sense. That's sort of consistent with, it's an understandable mistake that people might make. But the other circumstance that this current statute applies to is a situation where you have not mentioned a child that was already born. You have not mentioned a child that's already born in the statute in your will, and the currently existing statute creates sort of the presumption again that you sort of forgot about the child, where it's an existing, it's a child that's already born. That's a much more of a stretch to say that you just sort of forgot about your child. And what the current statute requires is that you come pretty close to saying, if you have Joan, John, and Sarah as your children, it comes pretty close to saying, if you don't want to give any of your estate to Sarah, you pretty much need to say, I'm not giving anything to Sarah. It has to be it doesn't have to be exactly that, but it has to come very close. And there are a series of Supreme Court decisions construing the statute that I think have sort of created some pretty harsh results. And I'm not, please don't misunderstand me, I'm not criticizing the courts for their decisions. I think they were making decisions based on prior decisions that, going back well into the 30s, including some, frankly, that I wrote. So, but I don't think that the court, including in the most recent decision, interpreted the statute incorrectly. It's just the statutory language itself is pretty harsh. And the other thing that is, I think, is another particularly harsh area of the current statute is that it provides that when it applies, the pretermitted heir takes under the will as just as if it will take an intestate share under the will. And so what that can mean is that if there's let's say that there are 3 children, the will only mentions 2, and the 2 get a certain percentage of the estate. If the one that's not mentioned is determined to be a pretermitted heir, that child can get an inordinately large share of the estate because that child would take under the intestate succession as if there were no will, which can really operate unfairly. So this statute changes the method of distribution to sort of make it more in line with what the testator is likely to have meant. It applies, as I say, it applies only in the circumstance of actually in 2 circumstances. One, in the circumstance of a child born after the will is made, and the second, in the circumstance of a child born before the will is made, if it is shown that the testator believed the child was dead. In other words, the child, let's assume it's an adult child. The child goes off to, tour Europe, and the parent never hears from the child again, and years and years and years have gone on, and the parent believes that the child is dead. In that circumstance, the pretermitted heir statute would apply, and it provides that, as you'll see from the terms of the statute, it creates circumstances that are designed really to be what much more likely to be consistent with what the testator likely intended. So, just to give you one example, it says in paragraph 2A, if the testator had no child living when the testator executed the will, an omitted after-born or after-adopted child receives a share in the estate equal in value to that which the child would have received had the testator died intestate, unless the will divides all or substantially all of the estate to the other parent of the omitted child, and that other parent survives the testator and is entitled to take under the will. And so what that is designed to cover is in that circumstance, in other words, where the testator doesn't make provision for an omitted child, but has left everything to let's say it's the husband that died, has left everything to the mother of the child, the presumption would be that the testator intended that the mother would then take care of the child when she dies. And so that's why that's kind of carved out as an exception. But as you'll see from reading, from going through it, it basically is designed, unlike the current law, to provide for distribution much more in line with what the testator likely intended. And as I say, this bill has been reviewed by a number of probate attorneys in New Hampshire, all of whom have made suggestions which are incorporated in here. And so I think it makes a great improvement in current law, and I hope you'll see fit to adopt it. And I'm happy to answer any questions.
Thank you very much for your testimony. Are there questions? Senator French and Senator Gannon?
Thank you, Madam Chair. Thank you, Representative. So this changes nothing if a child is mentioned and left nothing in the will, correct?
If the child is mentioned and left, in other words, yes, it doesn't, if you can still say in the will, you know, I'm leaving nothing to Joey, or I'm leaving nothing to Jane, yes, and that would not change that at all.
Okay.
Senator Cannon?
Senator Whitley and I are having flashbacks about the rule against perpetuities, but thank God that's not here.
Please don't ask me any questions about it, because I'm not sure.
I won't either. No life in being something. Anyways, if an heir is not mentioned, as Senator French was saying, in the will, I usually throw this in. I've written hundreds of wills, and whenever I throw in the phrase, it says, you know, anyone not mentioned is intentional. So that leaves them out from getting it correct.
Right, although, you see, that's one of, yes, that's the intent.
Quick follow-up. And then, so is it the law now that when you have that later child, or are you adding it that the later child born is, you're inferring that I would have included them?
Right, yes.
So that's what you're doing. You're adding, that's half of what you're adding, right?
Right, in other words, right, it's designed it's designed, the law will still cover the circumstance of a child born after, born after the will is made. But, you know, just to go back to your original question, I think it is at least somewhat, in light of the most recent Supreme Court case, I think it is at least somewhat an open question. If you simply say, you know, anyone not mentioned in this will is not, that may be enough, but it may not. It may be that, you know, if you have 3 children and you don't want to leave any to Johnny, you may need to say, pretty close to saying, I'm not leaving anything to Johnny. If it's just anyone not mentioned, maybe that's enough, but there's this recent case that it came to a, you know, the court required you to be pretty darn specific about who you want to disinherit.
Quick follow-up. So you're going to make wakes really unfun if your people have to call people out specifically. Family's going to be fighting.
Right. Well, this is sort of designed to alleviate that situation of already existing children. In other words, it does not, it will, if the children are already born, then the pretermitted heir statute would not apply to them. It's only children born after the will was made, or children where you think the child is dead. A child born before the will is made, but that you think the child has died, and that's why you haven't made any changes.
I'm clear. Thank you.
I have a question, and I'm not sure how to put this question. We have a burgeoning science here that everyone is taking advantage of, and that's genetics, where a lot of people like to get their genetics done, find out, you know, where they came from, and so on and so forth. And you're starting to see these cases where someone is either genetically not related to one of their parents, and neither parent realized that this child was not related to both of them, or you have someone who might have stepped outside of their marriage and conceived a child with someone else. Right. How do you account for those children? Are under this law, are those children, because they are this person's child, are they going to be able to come in and say, well, this person is my father, and I want to be included in the will?
I don't think, this bill, as you'll see from the language of it, it applies to both a natural born child and an adopted child. Right. This bill in particular doesn't sort of address, as current law under the current statute, doesn't address all of the implications of that kind of situation where, for example, if someone stepped out of the marriage, and let's assume that let's assume it was the father, and the father didn't know that the child, that the woman he had a relationship with had a child, and there had been no contact or something like that. That, I think that the question of whether or not that that child's rights to inherit and from who, I think would probably not be addressed by this, but it also is not addressed by current law. So I mean, but those are, you're right. I mean, those are questions that are, going to become more and more matters an issue, I think, as time goes on, as we get more ability to determine genetically those kind of things.
And also, the other question I had was, we know that many people have children that they give up for adoption for a variety of different reasons. And what about a child who was given up for adoption and they then locate their parents? They find their parents. Are they going to be able to, their biological parents, I should say, are they going to be able to take part in this as well?
No, I would say no, because in order for there to be an adoption, the parental rights of the prior parent have to be terminated. So I would say no, that they would not.
Okay.
Or at least as to the parent whose rights were terminated. I mean, if they were only terminated as to one parent, the other parent might apply, but not to the terminated parent.
I'll have a feeling that sooner or later we'll see starting to see cases like this in our courts. So
I'm sure that's.
I was thinking about this as you were talking about, children, and it's not as easy as it used to be. It can get very complicated, and I think the court is going to be the only way to sort it all out. But I appreciate you answering my questions.
For sure.
Are there any other questions for Representative Lynn? Seeing none, thank you very much.
Thank you.
Okay, are there any other members of the public who would like to speak to House Bill 1448? No? Okay, I guess not. We'll close the public hearing. Thank you. Okay. Are you ready, Jenny? Okay. We are going to go ahead and open the public hearing on House Bill 1579 and recognize the prime sponsor, Representative Gould. Good afternoon, Representative.
Okay, I am Representative Linda Gould, District 7, Bedford, New Hampshire, and thank you for letting me introduce this bill, 1579. I'm a knowledgeable advocate of many economic, community, and environmental and health benefits of rail trails in New Hampshire. And I have identified a barrier to rail trail development in the proposed legislation that the proposed legislation can remedy. Where active rail lines exist, and often the corridor that provides the best connecting link for our statewide rail trail network. It's often the same place. Owners of active rail lines are justifiably concerned about potential liability from shared use of their right-of-way. This bill seeks to overcome that liability concern, as legislation has done in other states, including Massachusetts and Maine. That legislation in the other states has been used to help us make this legislation as amended and passed in the House, and no further amendments need to be made to change it as far as we are concerned. This bill, as amended in the House, will advance our ability to create a world-class network of recreational and alternative transportation trails in New Hampshire. And that's the ultimate goal of this legislation, to help that happen in New Hampshire. I thank you very much.
Thank you very much for your testimony, Representative. Are there any questions? Senator French has a question.
Just a quick one. Thank you,
That's a
Madam Chair.
question.
This will take the liability off from the railroad's owners in case of an accident. So therefore, they would allow the use of their property, correct?
That's right, or next to it even, you know, if it's part of their property, next to the rail trail, or, yes.
Yeah,
Right.
thank you.
It's sort of, I compare it in layman's term to how people let people hunt on their property and they're not liable. That's how I compare it.
That's what I was thinking. Thank you.
Okay, thank you too.
Okay, let's see. The chair will call Craig Rennie.
Good afternoon. My name is Craig Rennie. I'm the Chief of the Bureau of Trails at the Department of Natural and Cultural Resources. And the department strongly supports House Bill 1579 as amended by the House. By way of background, the Bureau of Trails administers and maintains multi-use trails on state, federal, and private lands, which includes over 1,000 miles of OHRV trails, 300 miles of state-owned rail trails, and over 7,000 miles of snowmobile trails throughout the state. The majority of our statewide trail system occurs on private land because of the generosity of landowners that we work with. One of the major reasons landowners are willing to support public access on their properties is because of the liability protections landowners have with the existing duty of care law and the limited liability laws as well. Motorized and non-motorized trail use in New Hampshire plays an important part of our tourism economy, contributing over $1 billion of direct economic impact to New Hampshire annually. Also, access to trails is important to the quality of life of our citizens. So we believe it's critical to ensure that the duty of care law does what it's intended to do, which is support public access by protecting landowners. We appreciate that the House amended the bill to address several recent liability concerns that were not expressly covered under the current duty of care laws under RSA 212-34. The House bill with amendments addresses our concerns related to the following situations and examples. One, landowner lease agreements with the state for trail use, railroad property and right-of-way designated for recreational use, and then trails located on state lands. So House Bill 1579 includes a change to the charge definition that includes a lease of such land for said purposes to the state or any political subdivision thereof shall not be considered a charge. So the Bureau of Trails has lease agreements with several large landowners around the state to allow recreational use on their properties. And we agree with this change to the definition, as the duty of care protections then remain available to those landowners who enter into these lease agreements with the Bureau of Trails. Without this change, I think we would be in danger of losing access to 100 miles of trails in the state. House Bill 1579 also includes changes to add railroad property and railroad right-of-ways, which you've heard, to which public access is permitted. So we agree with these changes as well to ensure that the railroad corridors that are designated for recreational use are protected by the duty of care laws and remain open for future use. One example, just to share this afternoon, is relative to the importance of this change is our Corridor 13 snowmobile trail, which is in Bennington, New Hampshire, which occurs on an existing railroad property, was closed this past snowmobile season based on insurance company concerns over hazards on the trail. So again, this would afford those duty of care protections on those railroad right-of-ways. And then finally, just as a housekeeping measure, the amended bill modifies the landowner definition to include the state or any political subdivision thereof. This is to ensure consistency and mirror the existing landowner liability statute of 50814. So again, thank you for the opportunity to provide testimony, and happy to take any questions.
Thank you very much for your testimony, Mr. Rennie. Are there any questions from the committee? Senator Khan.
Thank you, Madam Chair. This is an important bill in my area where we're trying to link up with other states.
Yep.
And is this comparable to the kind of liability coverage that exists in those other states?
Are you referring to like other New England states?
Yeah.
It's very similar, yep.
Massachusetts, Vermont.
Where we have private land open for recreational use, correct.
Right.
Yep.
Very good. Thank you.
Thank you.
Are there any further questions? Seeing none, thank you very much. Okay. Next, we are going to call Marissa Chase, and you have Roger Turgeon. Are you going to come up together? Doesn't matter, either one.
Good afternoon, Madam Chair, members of the committee. For the record, my name is Marissa Chase. I'm the Executive Director of the New Hampshire Association for Justice. And this is, Roger, do you want to introduce yourself for the record?
Yeah. Good afternoon, Madam Chair, Senators. My name is Roger Turgeon. I'm a Governor at Large of the New Hampshire Association for Justice. Been an attorney for about 42 years, most of those in New Hampshire. And I live in Rochester and practice in Dover.
So originally, we opposed House Bill 1579 when it was introduced in the House. We had concerns that it broadened our recreational immunity statutes. However, I want to thank House Judiciary Committee, in particular, Chair Gordon, for making some good changes to the bill. We are almost at a point where we could support the bill. There's just one change that we would like to see that we believe leads to a loophole that is unintended and unrelated to the intent of the bill. As we see it, House Bill 1579, aside from the charge language, basically codifies current case law, in particular the cases Dalbert v. Laconia and Cohen. Those cases interpreted our recreational use statutes and expanded the definition. So what you see on the books is not necessarily how it's used in practice. However, we believe that House Bill 1579 largely mirrors those cases. And I'm going to ask Roger to talk about the charge language.
Sure, thank you. And thank you for your time and allowing us a couple of moments. I'm an avid outdoors person. I've been supporting Rails to Trails Conservancy for, I don't know, well, since they started 35, 40 years ago. I love getting outdoors, and I think they're a great thing. As Marissa said, NHAJ as a group and does not oppose, we don't oppose the intention behind 1579. And the way it's been revised to come to you is just about close to supportable. There is one unintended consequence that I see in the statute, and it's in the redefinition of what a charge is. As you know, recreational immunity has been part of the law of the land in virtually every state in the country for a very long time. Its basic premise is if you have property and you're willing to let people use it for recreational reasons, and if you don't charge them, you let them use it for free, we're going to encourage that by saying you can't be held responsible for damages that happen. Even if you might have been negligent in allowing a defect on the property or something, you can't be held responsible for that because you're letting them use it for free, and that's a good thing. We believe the unintended consequence in the new language defining a charge, and the one that specifically says if you're leasing the property, that's not a charge, and therefore you don't lose this immunity. The unintended consequence there is one could take a profit-making business around outdoor recreation and give yourself immunity by simply leasing your property to a nonprofit. If I, for example, own a go-kart facility, I might be taking in a couple $100,000 a year in revenues, and after my expenses and paying my employees and marketing and all of that, I'm making maybe a very modest $50,000, $60,000 a year. That's my profit. That's my job. But I'm responsible to make sure it's done properly with reasonable precautions to make sure the people there don't get hurt. That's how it should be. If I then create or find a nonprofit that's dedicated to recreational use, I have my spouse set up 401c3 for recreational purposes, and then I lease my property to that nonprofit. I could lease it to them for the $50,000, $60,000. I'm getting my profit. But because it's now a lease, I'm not charging anything, and I'm immune. And I don't have to maintain that property and keep it safe anymore. I don't believe the proponents of 1579 intended it to work that way. It's just sort of an unintended thing. We don't oppose being able to lease your property to the state or a city or some political subdivision. But when it comes down to leasing it to a nonprofit or to a trust or some other entity like that, then we believe language like saying, if you're leasing it for a nominal amount, for a nominal fee, nominal consideration, whatever language you want to use to make sure that it's a nominal amount. You're not making your usual profit on it. You're just letting people use it for free, then great, you've got the immunity. So our difficulty is with the lack of that language, and we've asked for a very modest amendment to it to add the phrase for a nominal fee or for nominal consideration somewhere in the sentence that discusses leasing it so that we avoid that possible loophole. Thank you. Any questions? We're here.
Yes, thank you very much. For your testimony, Senator Khan has a question.
Thank you, Madam Chair. I think we're talking about paragraph 2.
I'm sorry, I really should have pointed that out. It's the new section 1 in this section,
Line 7.
a charge, and basically the last sentence of it. So it's line 7 on the document. In addition, a lease of such land for said purposes to the state or political subdivision thereof, or to any nonprofit corporation, trust, or association shall not be considered a charge. Somewhere in there, the appropriate language of for a nominal amount or nominal fee would fix our concern.
So in addition, a lease of a nominal fee.
A lease for a nominal amount or for a nominal fee to any of those entities, then it's okay. They're doing it for free. They get the immunity like anybody else.
Are you all set, Senator Khan?
I am. Thank you, Madam Chair.
Are there any further questions? Seeing none, thank you very much.
Thank you very much.
Next, we're going to hear from Jason Sukup.
Good afternoon. My name is Jason Sukup. I am the board secretary of a nonprofit organization called Manchester Moves. We're a trail development organization in the city of Manchester. We've been around for 14 years, and we've made a lot of good efforts at developing a comprehensive rail trail network in the city of Manchester. We have built a trail that goes west out of the city. We've built a trail that goes east, and we've built a trail that goes south. Unfortunately, we can't go north. We can't get to Concord. We can't close what we call the big gap, the big problem in the Granite State Rail Trail. The Granite State Rail Trail is a nearly contiguous 125-mile off-road rail trail. Right now, we're at 58 miles is the longest length from Boscawen to Lebanon. That's the northern section. That's awesome. It was ranked number 12 in Outside Magazine this month as the top rail trails in the nation. Pretty good. The southern section right now goes from Manchester Regional Airport down to Salem, which goes on farther into Massachusetts. Rail trails have been in development since the 1980s, and they've made great progress on building them on abandoned railroads. Where we are stuck is where there's still a railroad for some reason or another. We still have a freight line that goes north-south from Manchester up to Concord, delivers heavy things like concrete, things that belong off the roads, makes sense, not going anywhere anytime soon. We've been in negotiations with Pan Am Railways on numerous occasions, asking if we could use an application to close those gaps called Rail with Trail. And the pictures I gave, the second photo in there shows an example of what that is. Those have been used in other states to close the gap. They've been used in Maine, they've been used in Massachusetts. There's over 380 of those across the nation right now. So in these last connection areas, they're the things that have to happen to make them connect. Something that happened in 2020, Pan Am decided to sell themselves. They sold themselves to CSX Railways for $180 million. That transaction is expected to close in May, next month. We've been in active negotiations with CSX about this opportunity for the city and the state of New Hampshire, and they are open to the concept. Good news, right? We can finally have our statewide rail trail. Rightfully so, they've said that there's a liability concern, and they don't want to get sued. Through our partnership with Rails to Trails Conservancy out of Washington, D.C., the gap that's been identified is the legal barrier that is in our laws, our state of New Hampshire laws compared to Maine and Massachusetts, that doesn't give them the same kind of protection. So this law that's in front of you today and as amended is a replica of that. And so if we have this law, we are confident that we will get permission to use this land for public access to close the gaps in the Granite State Rail Trail. Absent it, we have options like the first picture that's in front of you. That's my daughter. She's 10 years old. We ride a bike school bus across the city of Manchester every day back and forth as transportation. There's 12 children on that school bus who ride. We anchor it with 2 adults in the front, 2 adults in the back. We wear very bright colors, helmets, and everything. That is the best option we have. It's the only option. We look to our right, we see an old freight corridor that's 90 feet wide. It gets used about once a week at about 3 o'clock in the afternoon, once. The railroad tells us that it's a risky situation to do number 2. The second picture. There's a lot of risk inherent with that. You might disagree that picture 2 is riskier than picture 1. I can't think of anyone that would think picture 1 is safer than picture 2. Yet we use it because we want to be active. We want to be active as a household. There's other families who also want to be active. We actually see a lot of risk in putting our kids in the backseat of a minivan to watch iPads for 2 hours a day as we drive them to activities. So we are willing to take the risk, and we do like the bike lane. It's better than nothing. But we do see a much better option if we could change a state law. Everyone at our city is in favor of this, this project. It's been in our master plan. It's been in our planning documents for 14 years. We're excited to see an opportunity to finally get this project done. Our head of Department of Transportation, Victoria Sheehan, has reviewed this project. She is willing to build it according to federal standards and can do so. The only objection is getting permission from the landowner. The landowner is CSX out of Jacksonville, Florida. Coming in, they're going to own the whole region, all of New England, and they have multiple examples of this where they'll do it with, rightfully so, protections. So that's what this law is for. It's a very specific example of why this law is in front of you. It also has benefits for a couple other communities, including Nashua and Portsmouth, areas where they will also benefit from this law and be able to close their gaps. The reason we didn't agree to the amendment that was put before you by the people before me was that we just don't see the reason for it. We don't think there's any unintended consequences from it because we didn't see any unintended consequences in Massachusetts and Maine, and the bill is identical as amended. We've already peeled back a number of objections in the House because the law was much broader as it was introduced. This law is specific for railroads, only for railroads, no one else. We aren't talking about crazy examples of go-kart situations where someone might make $100. This is specific to railroad liability. We heard some of the benefits from state parks that these things offer for the state. I do think a statewide rail trail would be awesome. It would provide great benefits economically and for active people, for people who want to live in communities where you can be active safely. But that's not the biggest reason why you would do this. The biggest reason you would do it is safety. Those two pictures speak a lot of words. We do it for safety. We're not going to do it for money. We're not going to do it for anyone's profit. We're going to do it because we're going to save a lot of children for safety issues if we can. So we encourage you to pass, or ought to pass, this bill. I think is the language. We appreciate your consideration, and that's all I have. Do you have any questions?
Thank you very much for your testimony. Senator French has a question.
Thank you, Madam Chair. Thank you for coming today. Will your nonprofit have a lease over this land?
It's possible.
It is possible.
It is possible.
Okay.
It is possible because we still have to get to yes. And to get to yes might require money, which might require something in a lease. And so the language as produced in the amendment would limit our ability to offer an inducement to make this happen.
Follow up?
Yes.
It would seem reasonable. You would have a lease because you will have an investment and you'll want this to be more than a one-term or arbitrary agreement, correct?
We're looking for a 99-year lease.
Yeah, thank you.
But we will ask for free, but we might not get for free. If we can't get for free, I think there's a lot of supporters that might come up with some money to fund it.
Okay, thank you.
Okay, are there any questions? Seeing none, thank you very much for your testimony.
Thank you.
Okay, are there any other members of the public that would like to speak to House Bill 1579? Okay, see. Oh, yes, sir, please come forward, identify yourself for the record.
Thank you for the opportunity to speak. My name is Garrett McClarty, and I also live in Manchester, and I am also on the board of Manchester Moves, who Jason just spoke about there. So just to reiterate and to be brief, the language as in the bill right now reflects almost identically the neighboring states. And instead of introducing new language, we have gone off the precedent set by other states who have done this successfully. Again, our goal is safety for these kids. I work in the ER, and we want to see the community out and active and not coming with preventable illness, as well as thinking within Manchester, as you see in that picture. That is one of the best models of safety that we have right now. We have, within that first picture, there's a bike lane, and there are many sections without bike lanes. We'd like to see more of those, obviously. But there's a great need. If we look at countries that have successfully addressed the public safety risk, the gold standard is to move kids, especially kids, as they are learning awareness and sometimes forget as they use bikes for transportation and begin having habits that will follow them through the rest of their life to be active and to prevent these huge amounts of illness we see in our country with obesity and chronic inactivity, to get them started at a young age. And there's many parents who are not willing, like Jason, to let their kids bike to school. There's a Safe Routes to School program, and we do our best we can with that in New Hampshire as well as nationally. But to move the kids off the road onto protected bike lanes, both for their safety, and then, as we also see, it also provides a safe option for many other members in the community, whether they're biking or walking, to have a safe way to go. So I just would ask that you guys consider this and pass this for the benefit of our community. Thank you so much.
Thank you very much for your testimony. Are there any questions from the committee? Nope, you're all set. Thank you. Last call, are there any other members of the public who would like to speak to House Bill 1579? Okay, seeing none, we'll close the public hearing.
Very.
Thank you.
We're gonna be done faster than we thought. Yeah. Go see my guy. He's got the templates all made.
What?
Huh?
Okay. Okay. Let me know when you're all set, Jenny. We're gonna go ahead and open up the public hearing on House Bill 238 and recognize the prime sponsor, Representative Query. Did I get that correct?
Yep. Good afternoon, Madam Chair and honorable committee members. First off, I want to apologize for my casual appearance. I had a little bit of a nosebleed and ruined my shirt this morning, so I had what I had in my car. For the record, my name is Joshua Query. I represent Manchester's Ward 9, Hillsborough District 16, and I'm here today to introduce House Bill 238. I'm introducing this bill because the gay panic defense is a legal strategy that asks a jury to find a victim's sexual orientation or gender identity expression is to blame for a defendant's violent reaction, including murder. What we've seen around the country is that this discriminatory gay panic defense is used successfully to excuse the murder of members of the LGBTQ+ community. This is a bipartisan bill with coming out of the House with a 223 to 118 vote. This bill will ensure that this type of defense can never be used in New Hampshire. Let me begin with what this panic defense means. When a perpetrator uses an LGBTQ+ panic defense, they are claiming that a victim's sexual orientation or gender identity not only explains but excuses a loss of self-control and the subsequent assault. This is currently allowed under New Hampshire law. This bill, HB 238, will ban the use of a panic defense on the basis of someone's gender identity, actual or perceived gender, gender expression, or sexual orientation. Someone's mere existence as an LGBTQ+ person does not constitute a reason or provocation to commit manslaughter. The American Bar Association opposes the use of gay panic defense, and since 2013 has called for local, state, and federal legislatures to curtail the availability of this defense. And let me be clear, this bill does not dismiss traditional self-defense lawsuits and does not deny existing due process defenses. This means that an LGBTQ+ person would not be immune from prosecution should they be accused of a crime. If passed, New Hampshire will join 13 other states and Washington, D.C. in banning this type of defense, and join 8 other states who are considering similar legislation this year, or this term really, including Virginia, which just passed this in the House and it is currently in the Senate. For our state, we would be proactive in protecting individual rights by barring this defense. Nationally, 1 out of 5 hate crimes are committed against LGBTQ+ people. To put this in New Hampshire context, in our state, 5% of Granite Staters identify as LGBTQ+, the equivalent of 60,000 people. This is not a small amount of our constituency. Our state values personal freedom, and our state also ranks very high in protecting LGBTQ+ rights. Over the past 2 years, I've had multiple citizens from across New Hampshire ask me and many other legislators to sponsor this legislation. Some are members of the LGBTQ+ community who fear that this law would excuse their murder. But mostly, I've heard from people who have friends or family members who are queer and have seen this defense play out in other states and do not want to see the same thing happen here. This legislation would just simply be correcting an oversight that is needed to grant the LGBTQ+ people of New Hampshire the security that this cannot be used against them or their loved ones. Thank you for your time, and I welcome any questions.
Thank you very much for your testimony. Are there questions from the committee? Senator Whitley.
Thank you, Madam Chair, and thank you for taking my question. So you mentioned that 13 other states plus DC have passed similar laws. And my question is it similar both, in the scope and breadth and everything?
Yeah, it's very similar. Obviously, OLS has helped draft using some of those states' language. The one thing that is that ours is a little bit broad. Some of those states are older. After the murder of Matthew Shepard in Montana, where this defense was successfully used, back in the late 90s, states just made it a gay panic defense ban, which means that trans people could still, or someone could still use this defense against trans people. So mine is a broader spectrum to include all of the LGBTQ plus community. Yeah.
Okay, are there any further questions? Seeing none, thank you very much, Representative. The chair will call Representative Sylvia.
Thank you, Madam Chair. Thank you, committee members, for taking my testimony. Representative Mike Sylvia, Belknap 6, Town of Belmont. I have a quibble and then a serious concern with this bill. The quibble has to do with the circular logic that's applied to gender identity, where you're using the same word to define another word. And I find that problematic. I don't know why we can't have language that is very clear and describes the situation without using the same word. So that's just a quibble. The real concern comes down to the constitutional issue. In the state, our people, all people, are protected and are allowed to bring any defense suitable. And this seems to preclude that. So what I'm speaking of is Article 15, the right of the accused. And it says, every subject shall have a right to produce all proofs that may be favorable to himself. And he is to be fully heard in his defense. And so this bill is cutting off that right of defense. And I'm just one of those guys that really likes to stick to the Constitution. I was kind of wondering if I would hear about some activity that had happened in this state that would, require this bill. It sounds like it's a problem in other areas. I think New Hampshire is a very welcoming place, and I don't see that kind of. Obviously, there are incidents here and there, but I think that New Hampshire is a very friendly state. We're very close, small, and I don't see it as a current problem. Certainly sympathetic to the fears that others may have, but I don't think this is necessary, and frankly, I think it's unconstitutional. So with that, I'll be happy to take any questions.
Thank you very much for your testimony, Representative. Are there any questions from the committee? Seeing none, thank you.
Thank you.
The chair will call Jeff Strausen.
Hi, good afternoon. I'm Jeff Strelzen, Associate Attorney General at the New Hampshire Attorney General's Office. We are not taking a position on this bill. I came over to answer any questions that you might have about how these types of defenses work and our experience in New Hampshire with this type of thing in homicide cases, and also to point out a bit of an inconsistency in the bill. The last sentence in section 4A says, "Nothing in this paragraph shall preclude the jury from considering all relevant facts to determine whether the defendant was in fact provoked for purposes of establishing subjective provocation." So the first part of the bill essentially attempts to eliminate the defense, but the second part preserves a portion of it. Let me explain. In a provocation manslaughter defense, which is what this is geared to, there are two parts. There's a two-part test. One is an objective part and one's a subjective part. This bill attempts to eliminate the objective portion, but preserves the subjective portion. So I think how this would work is if a defendant tried to raise this defense, they would ask for a jury instruction on provocation manslaughter. And the judge would say, well, according to this bill, you don't get it, but you can still present all the evidence you want about it. And then their lawyer would get up and argue what's called a nullification defense and essentially say to the jury, you should excuse my client's conduct for all the reasons they talked about in the courtroom. So it kind of, we're making an observation that the bill tries to eliminate the defense, but at the same time, that additional sentence makes clear that a defendant would, in fact, get to put in all the evidence. So I think the legal distinction would be the defendant wouldn't get this instruction to the jury about this particular defense. Their lawyer could still argue a defense called nullification, which is defendants can get up in court and say, look, the judge told you the law is this, but you heard the facts. You, the jury, can still decide to disregard that and find my client not guilty. So it's a little inconsistent. Again, I just want to point that out to you that the intent of the bill may be to eliminate this defense. It definitely does not eliminate evidence about the defense, even though it may eliminate a formal defense itself. And I know it may sound like a minor distinction, but a jury is still going to hear this evidence about this issue if a defendant wants to put it in front of a jury. It'll still come in under this bill. So I apologize if that's a little confusing. I'd be happy to answer any questions you have about how these types of defenses work. I can tell you that I've worked in the office for 21 years doing homicide and murder cases. We have not had a defense like this presented. I can think of 2 cases where a defendant claimed that there was an attempt at a forcible sexual assault. We did not believe that was true, and the jury rejected that. So that's the closest we've seen in our homicide cases to something like this. But we have not yet had something like this be attempted as far as a defense. Doesn't mean it couldn't be, but just wanted to give you that factual background as well. And again, happy to answer any questions that you have about how the defense works or the law works in this area.
Okay. Thank you very much for your testimony. Senator French has a question.
Thank you, Madam Chair. Thank you. So in a case of forcible sexual assault that was actually upheld, would this prevent, if this law passed, could you use the gender identity and all that in that?
This law, as I read it, this law specifically precludes, does not apply to forcible incidents. So if a defendant, and again, the 2 cases we've had, the defendant claimed that the victim was attempting to forcibly sexually assault them. They claimed that they were acting in self-defense and or as provocation. They were able to make that defense, and we had to disprove it, and we were able to disprove it. As I read this bill, this would not prevent a defendant from raising a claim of forcible sexual assault. What it would prevent is somebody saying, hey, I found out this person is gay. They said they were interested in me. That made me so mad, I reacted. And what provocation manslaughter means is the provocation was so extreme, I lost control of myself, and what would otherwise be murder becomes manslaughter. That's what this bill seems aimed at, as I read it.
Do you have another question, Senator?
Just reading this. Yes, I do.
Okay.
Because it says in which the victim made an unwanted, non-forcible.
But that instance you just said wouldn't hold up anyways as a defense, would it?
As a prosecutor, I'd probably argue it shouldn't, but under the terms of this bill, the jury would get to consider it because the jury would not be precluded from hearing that evidence.
Okay.
And right now, the way the law is, the jury would not be precluded from hearing that evidence. A defendant could argue, hey, that's what happened. You should still find me not guilty. I, as the prosecutor, argue that's absurd. You don't get to kill people because you're angry at them.
Right.
But this bill preserves that. But my point is, if the idea is to get rid of that defense completely, it doesn't quite accomplish that. So,
thank you.
Are there any further questions? I've got a couple of questions. I would imagine that if somebody was subject to an attack or something happened to them because of their gender or their gender identity, wouldn't that be covered under a hate crime?
It could. This is a little bit different because what this is aimed at is cases where a defendant, in a way, kind of retaliates simply because of a person's identity. And it's really not about, this bill is geared at cases where there's simply no conduct at all. So obviously, if somebody were to try to sexually assault me and I were to defend myself, the law clearly covers that. I'm allowed to defend myself or a third person. The way the law is now, you simply can't. Let me back up. A lawful act cannot be sufficient for provocation under our provocation manslaughter law in New Hampshire. A lawful act. It must be an unlawful act to be sufficient. And an assault, attempted sexual assault, will be an unlawful act to be sufficient. So just the fact that if I were to say to somebody, you know, hey, I'm gay, if they were to get mad at me and attack me, that would seem to me that it seems to me that they would likely be precluded from claiming provocation manslaughter because there's nothing unlawful about what I just did. So, and again, I apologize for all these different nuances. I will tell you that the provocation manslaughter defense in New Hampshire is somewhat complicated. We've had a fair amount of litigation with it over the years. It's been difficult at times to understand and get clarity. And so I apologize that it's not quite crystal clear. I think the point, again, I want to make is this bill is attempting to negate this defense, but at the same time, it is preserving the ability of the jury to hear the evidence. So it's a bit of a double-edged sword. It's kind of gone, but not really under this bill.
Okay, because I was always under the understanding that if someone has been accused of a crime, that they are allowed to put forward any defense. And I always think of the scales of justice, that it's always weighed on the side of the individual who's been accused of a crime. And I'm concerned that if we say, okay, you can't use this as a defense, are we taking something away?
So there was a good point made about the constitutional provision about all proofs favorable. All proofs favorable gives a defendant wide latitude to introduce evidence in a court case, but it is not without limitation. The rules of evidence can limit it, and you, the legislature, can limit it. For instance, in an insanity defense, say, yeah, a defendant can put on an insanity defense, but they have the burden by a certain standard. Right. Here, again, on the one hand, it says, well, we're going to eliminate this defense, but on the other hand, it says, but you, the defendant, can still put in all the evidence you want about it. So it does, and here's how it would work, and I know it's hard for me to follow the times too. Under this bill, a defendant could not say to the judge, Judge, the case is over. I want a jury instruction that says my client can use the provocation manslaughter instruction. I, as the prosecutor, would cite this bill and say, no, Judge, you don't get to give that instruction. And the defense attorney would say, fine, and they would stand up in their closing argument and they would say, they would essentially argue this anyway. It's what's called a nullification defense. They would say, you, the jury, heard what my client said, how upset he got. He was upset because of things in his background, whatever. You should excuse his conduct because he was so upset. The defense could still argue that. They just wouldn't get the formal instruction from the judge. That's what this bill would allow. So I think it would pass constitutional muster, but I will tell you, I've not done a deep dive on that. Again, ours is not a concern as much as an observation that on the one hand, it takes away, on the other, it gives back. And we just thought you should be aware, you know, if people think this bill is going to preclude this evidence from the courtroom, this bill will not do that. The evidence, the claim that someone was inflamed because of someone else's gender or identity will still go in front of the jury under this bill. It will. It just won't be a formal defense called provocation manslaughter. It will be something else called nullification.
Senator Whitley has a question.
Yeah, so thank you, Madam Chair, and thank you for taking my question. So I see what you're saying, but if we just eliminated that last sentence, would that address the concern and make it more consistent? And would that pass constitutional muster?
Yes, two good questions. The first one is, it will definitely make it clear that the goal of the bill is to eliminate that defense. The constitutional muster piece is more difficult. I can't tell you right now. I will tell you that it will definitely engender litigation, and the claim will be that likely the claim will be that it does violate the Constitution because of the all proofs favorable clause. And that may have been the goal in putting that in, is to balance that. I don't know that. But the per se elimination of a defense is likely to engender a constitutional challenge.
That's what I thought. Okay. Are there any further questions? Senator Khan, you look like you have a question in there someplace.
Don't tease him into it.
I want to make sure if anybody has a question, that they get their questions answered. That's what's important here.
Thank you, Madam Chair.
And I apologize if I had made it more confusing, and I apologize.
Well, I do want to understand your points, and relative to this, this last sentence in paragraph 2, if it's eliminated, as I understand, this evidence would still be presented and considered. I mean, the judge would say, consider that relative to a subjective provocation.
I don't think that's how it would work. I think what would happen is that if the bill passed as it is, the judge would not give an instruction about that evidence at all. The defense attorney would stand up in closing and say to the jury, this is the defense I'm presenting to you, and would talk about that evidence. But the judge would not comment on it because the bill takes away that formal provocation manslaughter defense. Instead, it becomes something what's called nullification. Every defendant can get up and say, you jury, ignore the law because of these facts, and they can't be precluded from doing that. We have the absolute right in New Hampshire to do that. So the defense would get to do it. They just don't get kind of the semi-stamp of approval from the court that they're doing it. So it's a little bit of a distinction there. The defense attorney saying, please do this, and the jury would go back there and go, well, we don't really have any standards because we don't have a jury instruction, but they could still decide, yeah, the person was provoked enough, we're going to find them not guilty.
So the sentence, the last sentence there, is useful.
It depends on which side of this you're on.
And
I would simply say that it preserves the right of a defendant to put in this evidence. It does not preserve their right to claim provocation manslaughter defense. It allows them to claim a different kind of defense for which there's no jury instruction. Sounds like a minor distinction, but it actually matters in the courtroom.
Huge. Let me ask you this then. If we pass this, and if it was ever used, would it be grounds for appeal? I would imagine that it would be a huge ground of appeals, that I was denied my right to put forward a defense.
So that paragraph still allows the evidence to go in. I will guarantee you that, as with any new law, any change to the defense, there will be litigation, no doubt. Not having done any research on these laws or this particular form, I cannot tell you what that outcome likely will be, but I can guarantee you there will be litigation about it. It may be more likely to sustain challenge because it still does preserve a defendant's right to put this evidence in. The question is, because you barred them from claiming a particular defense, would that be enough to render it unconstitutional or not? It's not clear to me what the answer to that would be, but that sentence still allows the defendant to make these arguments. They just don't get kind of the formal approval from the court.
Let me ask you this. Do you think that this is a slippery slope? Because you can see other groups coming forward and saying, well, something happened and, I was beaten up or something. And, I'm just concerned about this because, I think a couple of years ago at political rallies where people were targeted because you're a Republican and you're a Democrat, that something similar can be put into law and people will not be allowed to put forward a defense.
If this bill completely barred the admission of the evidence, there would probably be a good argument that it may be unconstitutional on its face, but it doesn't do that. As far as whether it's a slippery slope, I think that's probably for you all to determine as to whether or not you think it's appropriate to pass this bill and whether there's a justified need for it or not. I can tell you that we in our office have not seen this type of claim before. We've seen something somewhat similar, but they've always been forcible cases, and those are very, very clear. So I can't speak to, is it really a slippery slope or not? I can't speak to that, so
Okay.
I'm sorry.
Yes.
It's not in the statute that it has to be. It's not in the statute that it has to be a criminal act to be provocation. Is there a case law?
There's case law that talks about that.
Is
and
that Soto?
No, it's not Soto. I can't remember which case it is, but in New Hampshire, there are a bunch of cases that talk about the provocation manslaughter offense, and you have to piece them together. But there are several cases that say that the act, if it's a lawful act, that is not sufficient for provocation. Lawful act.
Okay. Are there any further questions or comments? Seeing none, thank you very much.
Thank you for your
We
questions. I
appreciate you
appreciate
being
it.
here.
Thank you.
Okay, are there any other member of the public that would like to speak to House Bill 238? Okay, seeing none, we're going to close the public hearing, and the committee will be in recess until 4:30. Pardon? The committee will be out of recess. Can I get a motion to go into executive session?
So
moved. Moved by Senator Whitley, seconded by Senator French. Okay, what I'd like to do before we break for our dinner is to take a look at the bills that we heard today and see if there are any that the committee feels that we can exec. The first one, why don't we take a look at is HB 1036.
So,
This, it just says reinstates existing law, but makes it stronger.
I thought this was more confusing than what was already there. And I think it's odd that we can't think of, we're rewriting legislation for the same, with the same meaning. I don't
Well,
understand it.
it didn't help that the representative was talking about a different bill.
That didn't help.
And it just seems like there was a lot of confusion, but it just struck me that he said, this reinstates existing language, but only stronger.
No, more clearly, and I don't find it more clear, so.
Yeah, and we had testimony from the Municipal Association, this rewrites existing laws, so.
With ITL.
Second.
Okay, we've got a motion of ITL on House Bill 1036. Is there any discussion? Any further discussion on this? Okay, we have a motion of ITL. Okay, all in favor say aye.
Aye.
Any opposed? Okay, is there a motion for the consent
Move
calendar?
consent.
Second.
Senator French moves
Guys are
consent,
quick.
seconded by Senator Khan. Is there any discussion on the consent calendar motion? Okay, seeing none,
knows.
all in favor say aye.
Aye.
Any opposed? Okay, and Jenny, this is me again. Okay, next one is House Bill 1073, an act modifying attorney exemptions under RSA 91A.
I move in expedient to legislate.
Senator
Second.
Khan moves inexpedient to legislate, seconded by Senator Whitley.
How could you, to such a fine bill?
All right, 4-1, I guess.
Oh, it was well heard.
It just seems that everyone who came forward was against the bill.
No, the
And we
reps were.
fixed it last year, remember? With that Supreme Court case, there was a real concern about the work product and with attorneys, and I think we sent a very strong message with the language that we wrote that,
You created a categorical exemption for the attorney-client privilege rather than encouraging courts to engage in balancing of the public interest against the value of the
Right.
privilege.
and so did anybody hear anything that would change their mind today? I agree, okay. So we have a motion of ITL and a second. Is there any further discussion on House Bill 1073? Okay, seeing none, all in favor say aye.
Aye.
Aye, any opposed? Okay, is there a motion for the consent calendar?
So moved.
Moved by Senator Whitley,
I will second that motion.
seconded by Senator French. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Aye, any opposed? Okay.
Senator Castro, would you take that up,
We'll
please?
take this one out
Thank you.
too. Next, we have House Bill 1343, an act allowing limited legal services to be provided by certain paraprofessionals. We do have an amendment that was given to us by Representative Gordon. It's amendment number 1342H. And I do think that you have one? 1342H.
The bill is, the bill.
1343, where's the amendment?
He passed it out to us.
Oh, okay, all right, this
Yep.
one. Yeah, okay.
Okay, so we have this amendment. One of the, I don't think that there was no testimony against this bill. This sounds like a a good way to adjust what we have in the gap in access to justice.
It's one of the ones we heard today.
How about the dates?
I think the dates are okay, but one thing that I did bring up, and we just maybe wordsmith a little bit, is a report.
Yeah.
And that they should issue a report and letting us know how this program is working or it's not working. Because that's one thing we did when we did felonies first. We asked for a report to be issued, and that's how we knew that it really wasn't working very well.
I agree with that, and it sounded like the court was more than willing to do that.
They're willing to do that. So.
Do you want to do it after 2 years? How many years, or 1 year?
Well, I figured that,
Or a yearly
it would be
report?
2 years, July 1st, I just have July 1st, 2024.
Okay.
So give it 2 years, see how it works, and then gather that information and issue a report.
Oh, there's a repeal anyway after 2 years, right?
Right, and it will be at the end of the 2 years.
Right,
So that way, so Jenny, we're gonna need an amendment that is going to take, we're gonna put together an amendment with Representative Gordon with the addition of requiring a report that will be due by July 1st, 2024, which is the date of the repeal. Yeah, there should be. Do you think there's, I imagine, I just had here down, report to the general court on the efficacy of the program by July 1st, 2024.
It would read, the Supreme Court shall provide a report regarding the efficacy.
Right. Of the pilot program no later than July 1st, 2024.
So the pilot program established in section 1 of the bill.
So the concern the temporal concern that I've got with the timeline is, they said they needed to do some court rules. And so this isn't gonna get signed until July 1st. They gotta do some rulemaking. Then they're gonna do a summary report by July 1 of 24. So their 2-year experiment is really gonna be like 1 year.
So it's changed out
Right.
to January
But it's
1.
repealed, though. The program is repealed.
Well, then we can
Push
move
that date out,
the
too.
date on the repeal.
You want to move the repeal out?
6 months to January 1st of 25, or
Okay.
December 31
What do you
of
folks
25.
think? I know you're not a big fan of this.
I'm not a big fan, but I'm going along.
I would move the repeal date 6 months, but keep the starting date here so they can start as soon as they can.
Okay.
Yes.
Section 2 of this act shall take effect on July 1st, 2024. But we're amending language 3 to say the remainder of this act shall take effect on January 1st, 2023.
No, the other way around.
The other way around.
We're changing to July 1, 24 to December 31, 24.
Right. Yeah, it's the end of the year.
Give them through the end of the calendar year to,
December 2023.
And that would also change the date of the report as well, that it would be due in December.
or the end of.
Senator Whitley, can you help me? So we have paralegals, right?
I'm sorry.
31st would be
Oh, I
the
got it.
I'm sorry, Jenny?
So are we doing the 1st or the 31st? Senator Khan saying the 31st.
The 31st is fine. It doesn't matter either way. You just want them
Well,
to be able
I
to get
want
the
the first.
full.
Yeah, you stick to your guns.
Oh, geez, okay.
Just do,
Senator Gannon, you had a
don't you
question
just want to
for
do
Senator
January
Whitley.
1st?
Yeah, that's
So-
fine.
2025?
That's fine, whatever, yeah, it's fine, whatever.
Senator Whitley, you're more in the.
Wait, hold on 1 sec.
Oh, okay.
I think that we should do January,
Look at me.
I think that we should do January 1st, 2025, rather than December 31st, 2024. Is that okay with the judicial branch?
Is the start date January 1?
Yes.
If the start date is January 1, yeah, it may be January 1, that's fine. We're looking more.
No, actually,
start date is July 1st, 2022.
Right.
You just need time to be able to get rule forms in place.
Right, and that's what Senator Khan is talking about by adding the additional 6 months. Because knowing very well that, it might not even be signed by the 1st of July. And then you're gonna need time to do the rulemaking, you're gonna need time to develop the forms. So instead of it being a 2-year pilot program, it ends up maybe being a year and a half. So we want to give you that extra 6 months to run the program.
I appreciate that. If the start date, though, can also be January 1 of 23, so we have time to get the forms and rules in place, and then 2 years from now, at the end of it.
Well, what happens if you're ready in October? We want you to be able to go. You want us to wait?
The only reason is we get forms and rules in place so that the non-lawyer.
Okay. That's fine.
So what we're looking at are changing the dates, a start date of January 1st, 2023, and a finish date, because it sunsets, January 1st, 2025, with a report due on or by January 1st, 2025. Are we all clear on that? Okay, and we have the language that Representative Gordon gave us. That just cleans it up a little bit more.
There's one issue with that.
Okay.
Sarah Matson
Right.
pointed out, having to do with the thing that Senator Gannon identified, which is RSA 633:3-A is also is a criminal statute. And this would allow paralegals to represent criminal defendants who are looking at a period of year in jail. So if you just added to the reference 633:3-A, comma, Roman numeral 3-A, Roman numeral 3-B, and Roman numeral 3-C, and Roman numeral 3-D, that would capture the civil part of the statute that's buried inside the criminal statute that was discussed.
Very good.
I'd be delighted.
Very good.
And one last thing on the report, those are usually sent to the president, the speaker, and
Yeah.
the minority leaders.
You want it to the chair of Judiciary?
Now, usually it goes to the Senate President.
Usually, yeah.
And it goes to the Speaker of the House, and it goes to the minority leaders of both parties as well.
Also, there's the governor's office and the state library and.
We're gonna hold it for next week. Get it right.
Well,
No, it's easy.
the other thing too is that, this is only going to be for 2 years. And by having it come to the Senate and to the House, they're going to know whether or not they want to re-up this program.
So speaker's office, president's office, minority leader, and majority leader.
Yep. So let's,
To review everything, okay,
yes,
we're taking Representative Gordon,
amendment,
we're taking Representative Gordon's language.
yes.
We are changing section 2 of this act shall take effect on January 1st, 2025. Right?
No.
No,
That's the repeal date, but yes, on line 2.
That's section 2.
Okay.
On line 2,
Right.
section 2, which
Yes.
is repeal will be January
Yep.
1st, 2025.
correct.
The remainder of so line 3, the remainder of this act shall take effect on January 1st, 2023.
Correct.
Then we're adding language that says the Supreme Court shall provide a report regarding the efficacy of the pilot program no later than January 1st, 2025 for the Senate President, Speaker's Office, minority and majority. And then we're also adding in the language that Rick is sending me regarding updating the language that Sarah brought about in criminal defense.
Right.
For civil assault.
Maybe
Right.
exclusively for small. And that's
So it is RSA 633:3.
631.
Oh, I thought it was
633?
It's 633.
Oh.
A, comma, B, comma, C, comma, and D. Correct, Rick? You're all right. So, okay.
So moved.
We have a proposed amendment that makes a lot of changes. They're small changes, but significant changes. Is there a motion on the amendment?
Can I just ask Rick a question?
Okay.
Just
hold on.
quick, it would be really quick. So you took care of my criminal concerns, thank you. But they're still gonna hear custody issues.
Still going to hear
So
custody
big,
issues.
big, powerful issues that are important to be, real important.
So we're still going to hear custody issues. And the one thing I didn't hear anybody discuss is that domestic violence victims are going to be cross-examined by paralegals who aren't lawyers and may not have the training about how far the rules can go. Lawyers will be supervising and responsible for the conduct, but it was all victim-oriented, and nothing in the bill says only victims get this kind of representation. There will be people who are accused of.
Usually have advocates in the courtroom as well.
And we didn't hear that concern raised by the coalition.
By the
Just
coalition.
pointing it out that it's a bill that runs both ways. So you'll have people who are respondents to domestic violence restraining orders being represented by paralegals.
And Senator Gannon, I understand your concerns about quality, but the alternative is
I understand.
zero
I'm with you.
representation.
I understand that part.
Right?
And having no.
I just wish we could do better.
Well, you know what we can do is fund more lawyers in the HLA. I'm happy to sponsor that next budget cycle.
We'll talk next session.
There you go. So we have a proposed committee amendment. Senator Whitley has moved ought to pass. Is there a second?
Second.
Seconded by Senator Khan. Okay, is there any further discussion on the proposed committee amendment?
I just want it noted that Senator Whitley and I were co-sponsors of this entire legislation.
Your name is all over this bill, Senator.
All over it.
All over it. You're good. You're good. Okay, we have the motion. All in favor, say aye.
Aye.
Any opposed?
Nay.
Oh, okay, it's 4-1, okay. All right, so we have the bill as amended. It's House Bill 1343. Is there a motion?
I move ought to pass as amended.
Okay, Senator Whitley moves ought to pass as amended, and I will second that. Okay, so we have an ought to pass as amended. Okay, is there any discussion on the ought to pass as amended motion?
I think this is really innovative. It's
Yeah.
a very New Hampshire tailored solution with a lot of very smart people who have thought through the issues. And I think it's going to go a long way to bridge that access to justice gap that's just too huge right now.
And I think that it helps people who, right now, we see a lot of people that are pro bono that are going into court. They have no understanding of the courts, really. And it gives them a better case to put before the judge by having someone who's a professional. That they couldn't afford an attorney, but they could probably afford to pay a paralegal. And I think that's in the interest of all citizens in the state of New Hampshire. So I'm supporting this. I think this is a great idea. And it's only a pilot program. It's 2 years. If it doesn't work, we'll know, or whoever's sitting here in 2 years will know it's not going to work.
I want to add about the education opportunities that this presents in where there are workforce shortages. We generally ask our education institutions in the state to catch up and provide some type of pipeline. I don't think that we are attuned to the problems that our courts are facing with increased caseloads and the backlogs that exist. So if this is an efficiency effort as well as improving the quality of service, yeah, I think we need some more follow-up. And in this 2-year pilot, I think that we ought to put some emphasis on the development of coursework that could either be certificate for people who already hold degrees or something that gets built into the curriculum for 2- and 4-year graduates.
And we did have testimony that the courts are really backed up.
Oh, yeah.
They're really, really backed up. And so I think it's going to take us a while before we come out of, all the unintended consequences of COVID. And people deserve justice. And they deserve justice as soon as they can get it, not to have to delay and delay and delay and delay. So I see this as a step in helping us get there.
Justice delayed is justice denied.
Well, there you go. Okay. So we have
The granite gaze.
I was waiting for that. So we do have an ought to pass as amended motion. Is there any further comments or concerns? Okay, seeing none, all in favor say aye.
Aye.
Any opposed?
Nay.
Okay, so it's a 4-1. Senator Whitley, you want to take this one out? You and I will, we can argue this together.
And Senator French.
And Senator French.
Senator Whitley can take it out if she keeps it short and brief.
Senator
Jenny will do
French. Okay. Okay, next we have House Bill 1448, an act relative to the pre-termitted air statutes.
Yeah, I like this bill very much, and I move ought to pass.
Okay, Senator French moves ought to pass.
Second.
Seconded by Senator Khan. I think this is interesting. Yeah, I mean, you're gonna have to say, I don't want to give X anything. You'd be very, very specific in your will. If not, you're gonna get, the wills will constantly be challenged. I would think so. If if you decided you left one child out, and, or you, what if you, well, no, not you.
This will actually help a lot of these estates where they inadvertently,
They forgot they had children?
they wrote the will and then had another child and forgot to update it, died at 56 or 52 and didn't update it. And I see it a lot, or I see it often enough. And it goes back to dying in intestate, which the one that gets left out gets more than the other two.
Yeah, and it's the point that I brought up about a child that was born outside of a marriage and was not recognized in the will. Is this going to cause problems? Because they're going to have to prove they're biologically related to the father. Why, or the mother, why weren't they recognized? I just don't know if it's going to turn real messy.
So you've made my life much harder though, Senator, because I always put the simple clause that Rick knows we all do. If an heir is not mentioned in a will, that is intentional. Now, to have to call someone out specifically is really going to be mean and nasty and cause lots of fights in families. So it's going to be a big, no one ever wants to say, I don't want to give Johnny money because he's a loser. We've already wasted enough money on him. It's easier just to leave him out. Like, if we leave him out and you put that clause, we all said, and I used to say yes. But I guess I have to call Johnny out and say, nothing for you. It's just going to be harder for when I write the bill. What? So I'm gonna get 200 or 300 wills to rewrite. It's a wonderful day for me. But
Well, you're going to have to declare a
I
conflict of
will. I
interest.
certainly will.
And
Quite often.
I brought up the idea of genetics. People are doing all this genetic 23andMe and finding out all kinds of strange things that went on in their family they had no idea about. So to see the case law develop around this issue, I think is going to be interesting.
So if Harold had a child out of wedlock, which I'm sure you never have, but if you did, and they come in and say, and so there was no adoption procedure that ever ended anything, right? It's just stepping out, I think is Senator Carson's term. If he had stepped out and had this other child, can they go back? Can they go for Harold's stuff now?
Can they go?
In the will, can they declare that they have an interest?
We have a lot of bills to get through, friends.
Because that could be a lot of problems, but fine, whatever.
That's why I said, I think the case law that's going to develop around this issue is going to be very interesting and interesting to watch. So we have a motion of ought to pass on House Bill 1448.
Second.
Oh. I thought it was Senator Khan.
I thought so too.
Whatever.
Okay.
Okay.
Okay, so is there any further discussion? This is a great discussion, I think, just on something that most people don't really think about.
Right.
But anyway, we have it ought to pass. Is there any further discussion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Is there a motion for the consent calendar?
So moved.
Second.
Senator Whitley moves.
Yeah.
Consent with Jay.
Sorry.
Seconded by Senator Khan. Is there any further discussion on the consent calendar motion?
I'll go against it.
All in favor say aye.
Aye.
Aye. Any opposed? Okay, Jenny, I'll be here later than you guys tonight.
Yeah.
So
All right.
that's okay. No, that's all right. I'd rather it be me than anybody else.
We're keeping Jenny alive.
Okay, next we have House Bill 1579. We also have an amendment, which is amendment number 1472S. And I would like to make an ought to pass motion on the amendment.
472.
1579? I don't have an
This is the
amendment.
bill. 1579 is the bill. The amendment is 1472.
I don't think I have the amendment.
I don't either.
You were supposed to get it.
There is a
Everyone was supposed to get it.
I know what it is.
Yeah, what it does is, because,
Can we do a committee amendment? 'Cause
yeah, we'll do a committee amendment,
words.
because it's easy. There's just there's just insertion of a couple of words. Let me look here.
On line 7, right?
It is,
Oh,
yeah, it is in that first section, and it says a contribution or other voluntary payment not required to be made to use such land shall not be considered a charge or fee within the meaning of this section, period. In addition, a lease of such land for said purposes to the state in addition, a lease, and it should say, insert in the words for a nominal fee. So that would be the committee amendment, for a nominal fee.
yeah.
Okay, that's exactly what this amendment did.
Great.
Chantel was supposed to send it to you, so, because I got the amendment I think it was last week.
Oh.
And so, okay. That's okay, it's okay, stuff happens. So we just have the insertion of the language for a nominal fee on line 7. And that would be a committee amendment. And I will move ought to pass on the committee amendment. Is there a second?
Second.
Seconded by Senator Whitley. Is there any discussion on the committee amendment? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay.
Move ought to pass as amended.
Okay. Senator French moves ought to pass as amended. Is there a second?
Second.
Second by Senator Khan. Is there any discussion? Okay. Seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Is there a motion for consent?
So
So
moved.
moved.
Moved by Senator Khan, seconded by Senator Whitley.
I think dinner's got its way.
Yeah? No. Okay, so we have a consent calendar motion. Is there any discussion? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay, Jenny, this one's mine too. And we have one last one, which is House Bill 238, an act prohibiting provocations based on a victim's actual or perceived gender, gender identity, gender expression, or sexual orientation.
I'm going to ask to hold on that one. I've asked the sponsor to work with GLAD to get a legal memo, and I think that'll be useful for the committee.
This bill was extremely confusing, what they were trying to do, and I think that there is some issues. So I don't have a problem, but we need to get it out, so. Okay, so we'll just hold this one.
Thank you, I appreciate
Okay,
that.
we're still in executive session. The committee will be in recess until 6:30. It gives people time to
6:30.
turn off your. states are passing laws anticipating.
I know.
Yep, okay. The committee will come out of recess. We are still in executive session. We are going to take up House Bill 609, an act relative to the scope of the Fetal Protection Act. Is there a motion?
I move ought to pass.
Okay, we have a motion of ought to pass by Senator Whitley, seconded by Senator Khan. Is there any discussion on this bill?
Yeah, I would just say, what we have different this year, just, some really compelling stories. And I think, for those women that did share their stories, came forward, gave us a real sense about what realistically happened in New Hampshire. I think it's time to do this.
Okay. So, anybody else? Are there any other comments? Senator French and Senator Gannon.
Well, thank you, Madam Chair. I think that I want to believe the doctors and that the doctors do not perform these unnecessarily after 24 weeks. And we've heard testimony after testimony that it just does not happen for convenience. So I'm going to believe the doctors and vote yes on ought to pass.
Okay. Senator Gannon?
I'm going to be voting majority on it, but I do have reservations with the wording, fetal anomaly. What does it mean? Incompatible with life. I'm scared by Iceland going down a road where they can say a kid with Downs is not incompatible with life. So while I would like further work on this, I think we'll do it next year.
Yeah.
Senator Khan, do you have a comment?
Well, I think this has been the most moving testimony over the last 2 years that I've heard. And I think to be unresponsive to this would be a failing of this body. So I'm pleased to hear positive thoughts about moving forward with this bill.
Okay. My 2 cents, I'm going to be supporting this. As I said earlier, when we did the first, the getting rid of the ultrasounds, we've heard from so many people across the state, and we've listened. We've listened to what they say. And while I share Senator Gannon's concerns about the language, I do believe it needs to be fleshed out more, and we need more concrete definitions. But I just think the idea of a woman being forced to carry a fetus that has passed away is something that we should address, as well as a child that is a fetus that can't possibly live outside the womb. As my colleague here, Senator Whitley, often says, I'm a mother. Well, so am I. And I can't imagine the pain and the suffering some of these women are going through. But I do think it needs more work. I do believe when we do get the final Supreme Court decision in June, perhaps that will offer more guidance so we can address this in the next session. So I will support this. Okay, so we have a motion of ought to pass. Is there any further discussion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay.
Move consent.
Okay, Senator French moves consent. Is there a second?
Sure.
Senator Gannon moves consent. Okay. Is there any discussion?
I would just say, I think the fact that we just took that vote means a lot, and it sends a strong message that when people come to the State House and share their stories, we listen. So it's moving.
Yeah, like I said, we heard from the people, and I think that's important that they know we heard their voice. So, okay, so we have a motion for the consent calendar. Is there any further discussion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay, Jenny, I get to do this one. Okay, next we have House Bill 1647, an act relative to the calculation of child support.
I move interim study.
Sorry, what number?
1647.
1647.
I would second the motion.
Okay, Senator French moves interim study, Senator Gannon seconds. I think the most compelling testimony for me was the testimony that we had from the individual who was part of the working group, and Mr. Matrumato, who said that that under our current statute, 90% of the cases are settled. So we're only talking about a small number of cases where there's a lot of arguing and fighting. And I remember previous testimony we've gotten about family court, that it's the same percentage. 90% tend to come to some resolution, and you just have that other 10% where people are arguing and fighting. So I don't think that we need to make the types of changes that we find in this bill. We did send them a bill from the Senate that addresses some changes. Last year, we had quite a few bills on child support, and Honey Hastings, a well-known family mediator here in the state, put together a working group. And that Senate bill reflects the job of the working group. So we'll see what happens, what the House wants to do, but I just don't think this one's ready. It needs a lot more work. Plus the fact, I believe, we had testimony that UNH is going to start their process of looking at everything again. So, which they do every 4 years, I believe.
Right.
So they're going to start looking, so, okay.
Yeah, the testimony is that, and we've heard this for the last 2 years, that at the end of 2022, there would be the updated report. I think if there's any message for us is, one, let's be informed by some data. And second, I hope that the department will, which I think is in a very good position to offer us some recommendations. And I hope that they do. They have some experts in HHS and long-term child support services, and I think we should ask them to make sure that this report is expeditiously delivered to the legislature with recommendations.
I remember, I was the chair back in 2018, and they presented their report and we adopted it. So what we currently have is their recommendations from 2018. So, yeah, I just don't think that this, this bill is quite ready to come forward.
I was moved when they mentioned in testimony that it would reduce every child support order. And
Yeah.
where are we gonna make up that money? Where are the families gonna get it?
Yeah,
So it concerned me.
Yeah, and I just think, you know, when you look at what we should be doing, what our policy is as a state is what's in the best economic interest of the children. And so I don't
Right.
think this bill gets us there.
Well, we changed that, I think in 2020, I believe, the 1920 session, where we changed it from what was in the best interest of the parents to what is the best interest of the child. So I see what we currently have and what we sent them is in the best interest of the child. So we have House Bill 1647. We have a motion for interim study. Is there any further discussion on that interim study? Okay, seeing none, all in favor say aye.
Aye.
Aye, any opposed?
Move consent.
Okay,
Second.
okay. Senator French moves consent, Senator Whitley seconds. Okay, is there any further discussion on the interim, on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay,
I'll have Senator Carson take that out, Jenny.
thank you, Senator.
It never gets old. It never gets old, right, Jim?
That's the way it is. Okay.
It's funny the first time, it's funny the 10th.
Next, we have House Bill 1682 FN. This is an act establishing the Law Enforcement Conduct Review Committee in the New Hampshire Police Standards and Training Council and making an appropriation thereof. We do have an amendment. Do you have that one, Jen? This is amendment number 1446. Oh, Senator Khan, this should be very familiar. You had,
yes.
you had asked
Never mind.
for a definition of administrative
I
suspension.
know what it
During
is.
hearing.
I know what it is.
And we put that, we added that amendment to the bill that we had in the Senate, which is a
Oh, yeah.
exact
Thank you.
duplicate of this bill. And so, just to keep things consistent,
Yep.
I had the amendment drawn up to include the language onto this bill.
Okay.
I move on to pass, and I did it before Senator Khan did.
What ought to pass on the amendment? Number
On
one?
the underlying bill and then on the
Okay.
amendment.
Second.
So Senator French moves ought to pass on the underlying bill, but also ought to pass on the amendment number
And I also
14.
second that.
Okay, 1446, and that is seconded, both of them by Senator Whitley. We've done this one before. They have our copy, we have their copy. So we'll just, hopefully we have an ought to pass motion on both, and we'll see what happens at the end of the day. Okay, so we have an ought to pass on amendment number 1446. Okay, is there any further discussion on that amendment? Okay, seeing none, all in favor say aye.
Aye.
Aye, any opposed? Okay, we've adopted the amendment. We already have the motions on the underlying bill, moved by Senator French, seconded by Senator Whitley. Is there any discussion on the underlying bill? Okay, seeing none, all in favor say aye.
Aye.
Aye, any opposed? Okay,
Move consent.
okay, Senator Whitley moves consent.
Second that motion.
Seconded by Senator French. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, so that one, we'll take care of that one. The only one that we have left that maybe we can talk about is House Bill 254, an act relative to the placement of minors in secure setting.
Okay, so I understand the intention of this, if I may, Madam Chair.
Yeah, go right ahead.
I understand the intention of this bill, certainly, because prior efforts, similar efforts have reduced the census at Sununu and made sure that kids were instead getting appropriate services. I was a little concerned with the testimony of both the county attorney and Rebecca Ross, who is the Director of Children's Behavioral Health. So Rebecca Ross testified a few things. One, that the way that the bill read, it would potentially limit kids who did get justice involved from getting into the system of care, because they wouldn't get the assessment that was Madam Chair's
Right.
bill last year. The other concern that I heard is that many times children are charged with a sexual assault or something and they plead down. That's a necessary thing, you know, so kids don't have these records, but they also get the services that they need. So I'm a little concerned with that. And then also there was this was perhaps the most alarming thing, that if we, as the language is written, I think the language was a little confusing, that children would be certified as adults, that it would push prosecutors to certify kids as adults rather than keep them in the juvenile justice system. So I certainly support the idea. I think it just needs some work, so we have to be careful of those unintended consequences, particularly because we have spent so many years and so much money on establishing the system of care. We just want to make sure that kids stay in the system of care rather than get diverted to the adult system. So I just think it needs work.
Okay, so we have a motion of interim study.
Depends.
Okay, Senator Khan is moving interim study.
So we do have an amendment by Representative Lynn. Do you have that? Do you remember?
Oh, okay.
And so I have on my notes that this is good if we add that amendment.
Okay.
We're not.
And we could do that as a committee amendment.
We gotta make sure, here's what I want. I would like the Office of Child Advocate and Rebecca Ross to weigh in on this amendment.
So we don't have to
can
do
hold
this.
it. I mean-
Yeah, we can hold it for,
Yeah,
yeah, this is not a fiscal note
No.
bill, so,
I
I
think,
withdraw my motion.
okay,
and I will get this to
Okay.
the OCA and to Rebecca Ross.
okay. Just to kind of get their ideas on
Yeah,
it.
on how it impacts the system of care.
Okay, let's see.
So what bills do we have left?
Look, the ones that we have, as of today, we have 13 bills left to hear. We have, next week, we're hearing 7. And so hopefully we'll hear those 7 and we can exec, hopefully them next week. And then the last week in April, we have 6 bills that we're hearing. And it's the same thing. We'll hear them, hopefully we'll exec them. I should be through with ED&A this coming week, so that would free up a Wednesday morning. So the last week in April, if we need to take a Wednesday morning, we probably can, but I don't know. You're in HHS? Okay. Well, are you almost through with Commerce?
Yeah.
Because if you're gonna be done the last week,
Yeah, that's all good.
if you're done by the last week in,
We'll be done.
okay, we'll have to figure that out. But we just have 13 bills left and we have to hear. And we have 1, 2, 3 that we did not exec. One is 1431, the Parental Bill of Rights. 1677, which deals with the settlement for claims of abuse, and 1476. Those are the ones that we do not have. We have an exec, and we will add to that. Let's see, 254, which we were just discussing, and Senator Whitley has asked us to hold House Bill 238. So we have 5 left. So anything that we have that has a fiscal note has to be out of here by next week. So that's where we are.
Okay.
We have done an incredible amount of work in a very short period of time. And we could not have accomplished it without all of you, honestly. with Rick and especially Jenny.
Thank you, Rick and Jenny.
Yeah,
Thank you, Rick and
for
Jenny.
all your work. And so hopefully, we can see that light at the end of the tunnel. This week was a tough week. Okay, all right, we're just gonna,
I would like to say for the record that I accept that, Senator, and I appreciate it, and I understand.
it's been, I hope the public realizes this has been a very long day for us. And so, it's a good thing we all get along so well. So is there a motion to come out of executive session? Moved by Senator French, is there a second?
Second.
Second by Senator Whitley. All in favor, say aye. Aye. Okay, we are out of executive session. We are done for the day. Thank you all so very much. I'm staying to do the blurbs with Jenny. And please, Jenny, you're doing the things for the calendar for